right, good morning and welcome to the Massachusetts Appeals Court. My name is Justice Walsh and I am very lucky today to be sitting with, to my right, Justice Hershfang, to my left, Justice D'Angelo. And I would dare say that everyone is very lucky to have the three of us as their panel members. We'll see when the decisions are ultimately authored, but that's how we'll leave it with that. For those who are experienced appellate attorneys, then bear with me as I explain a few of the House rules, especially for those who don't practice before the appeals court as often as others. As is our standard practice, each side is 15 minutes. There is no rebuttal at the appeals court. The lights will start and they will go green when you start your argument. Ultimately, when there's about a minute and a half left, it will turn to yellow. And when the light does go to red, certainly you can finish your thought or your sentence, but the clock goes in reverse order. Often attorneys think, I have 2 minutes left, and it's really that you're 2 minutes over, but we'll try just to wrap up whatever you're saying. And if the panel has questions, certainly we'll entertain the questions, but otherwise then your arguments will have to be resting with your briefs. If there are impounded names, et cetera, information, please counsels ask you to be sensitive to that. And just as far as order, we'll hear 3 cases, potentially not 1, 2, 3, but we'll take 3 cases. Then we'll take a brief recess and we'll hear the remaining 3 cases. So with that, I'm going to start with docket number 2025 P 1027. That is Commonwealth versus Daniel Figueroa. And attorney, is it Henrique?
Yes, sir.
Okay, good. Welcome. And whenever you're ready.
Thank you. May it please the court. Genevieve Henrique, presenting on behalf of Daniel Figueroa. Your Honors, this was a fact-driven case, and this analysis should be fact-driven as well. It would have been perhaps a different situation, not only if there had been a transcript provided clearly, but perhaps also if there had been a certified interpreter used and truly an agent of the defendant, as opposed to a key prosecution witness who is clearly not acting as an agent of the defendant.
Counsel, I want to make sure I have some, I don't know if I'll call them procedural, but information that's important to me.
Yes.
There's no allegation that the defendant was not provided a copy of the video, correct?
A copy of the visual video, that is definitely not,
All right.
no allegation.
And the defendant, defense counsel, was provided at least a summary of what the defendant said in English, which was contained in the detective's police report, correct?
I think that's a fair statement, yes.
All right. And lastly, on these procedural points, there was nothing that the detective said at trial that was a surprise to defense counsel based on the summary. Is that fair?
I don't know if I can comment on that because that goes to the heart of the issue. We don't have a transcript. There's a summary, but it was not word for word. It was not the exact question and then the exact answer. And defense counsel was not given the opportunity to review an English transcript to see if there was, things that were more, because he certainly expanded beyond the police report. So I don't think as appellate counsel I can sit in a position and
was there an objection to him going beyond what was in the police report during the examination of the detective?
There was not a specific objection to an expansion of the summary that was included in the police report.
And lastly, I guess that opened up a further question. I'm sorry to my colleagues, I'm hogging you. Is there anything in the record to suggest that defense counsel did not get a transcript of the video on his or her own funds and get his own transcript of the? And you can be careful about what you say. I asked what's in the record.
Right, and that's what I'm just specifically looking back to. In the record, it is discussed as part of the motion in limine that Commonwealth is seeking to provide the video without audio. There's nothing beyond that that suggested that the defense counsel ever had access to the audio.
Okay.
So that was my question, because you carefully crafted it your answer, which I really appreciate, is that, yes, we had the visual. And so are you here today saying that on this record that the only thing that defense counsel got was the picture of a conversation without any audio whatsoever?
And I think I can speak within the record too, because of the motion for the new trial, that yes, that would be what has been was what was suggested to the court, and certainly suggested at the motion for a new trial. Now,
Wait, now I'm confused.
okay.
When I said there's no question he got the video, maybe I wasn't clear.
Yeah.
When I say he got a video that had an audio portion to it, didn't he?
The suggestion, and again, going within at the Rule 30 motion, which is part of this appeal, the suggestion is no.
And defense counsel was not called at the Rule 30 motion, correct? As a witness.
No,
Wouldn't that be an ineffective assistance claim?
no, Your Honor, and again, trying to do my best to stay within the record here. Defense counsel was not called because there potentially would have been strategic reasons to not act further with what they had.
Okay,
She
okay. Now let's get to the heart of your argument, and before I pummel you with more questions, I'll let you say a few things.
I know I probably won't get much. I think Your Honor just led right down to where my heart and where heart of the issue to me when I was briefing this case came down to a judge recognized, the trial judge recognized that the substance of the interview should not come in at the case in chief. I think everybody could agree that that was a correct judicial decision. Just by the defendant utilizing his opportunity, exercising his opportunity to testify against himself, which was the only way that the issue of self-defense was going to be raised, which was a very vital issue in this case, exemplified by the fact that the jury came back with two questions, and one of them was specifically to what are the elements of self-defense. They were considering this, and I think that's where, when I began my argument, suggested that this analysis needs to be fact-driven. It might be a very different analysis if self-defense was not an issue, and there was not necessarily the chilling effect on whether or not my client should have testified.
How is this any different, though, than any other case in which the defendant elects to exercise his or her right to testify in their own defense, and something inconsistent or a statement that could be impeached? Because to some degree, especially hearing your position about whether an audio was provided, I want to separate for a moment the Spanish-speaking nature of the statements. Okay, and so let's hypothetically say that didn't exist in this. We'll make it clearer, right? The Commonwealth didn't provide a statement that it ought to have. And the judge in the case in chief said, Commonwealth, you're not going to be able to provide, you're not going to be able to call the testimony and introduce that. But the defendant testifies as to something that's very different than what he said to anybody, but in this case to a police officer. Couldn't, in that instance, in my hypothetical, the Commonwealth, as rebuttal, call the police officer to testify about the inconsistencies in the defendant's statement?
And certainly, the point you raise it has its points, and it's something that I've struggled with. But I think the
Okay,
crux-
but so then you're asking us to make a different rule when someone speaks a different language, right? Even though there was no potentially audio, but you're asking us to have a rule for statements that are in English that could be impeached,
We essentially do have a rule, and it's Commonwealth v. Portillo, in the sense that it is suggested that a transcript should be provided. In this case,
Right.
it was not.
That isn't Portillo, isn't the language in its case in chief?
It is case in chief, and yes, I
doesn't
am
include
looking,
rebuttal,
I am
but-
asking this court to expand it.
Okay.
That is what I'm asking this court, because I think the safeguards that the court in Portillo set out to establish should expand to trial counsel when trying to prepare for trial to know whether or not it was, for example, just a minimal error, such as the language in the Vasquez court used, or whether there was substantive difference between what his client said, which he did not have the opportunity to, and again, there was an attempt to record whether or not his client said what he said, or an agent of the Commonwealth, somebody certainly with a stake in the outcome of the case, in a case where self-defense played a primary role to the trial strategy, that yes, that Commonwealth v. Portillo should be expanded and should have protected this defendant and not put him in a position, put him at the disadvantage when he chose to testify.
Can I expand on Justice Walsh's very fine question? Mm-hmm. Even in cases where a defendant's statement is suppressed for a Miranda violation, let's put aside voluntariness, but a Miranda violation, a telephone call violation, something like that. Once the defendant testifies, even in those remarkable circumstances where it's suppressed because of a clear police violation, that statement can be used against the defendant. So you're not only asking us to expand Portillo, but in a way you're asking us to ignore those other cases.
I'm asking you to recognize the safeguards that Portillo was trying to establish in a case where self-defense was at issue, where the fairness was a significant issue in that we had not just the violation, or the lack, I shouldn't say violation, but the lack of providing the transcript, the officer being able to testify to the substance of the statements, but then also, again, self-defense being very important, these medical records being introduced that also give authority to that officer who now is speaking to his translation of the defendant's statements, and give added corroboration or authority by stating that essentially suggesting that the defendant started to change his tune and complain of these bruises and lacerations, which we know he has, but with the statements within the medical reports, the ambulatory report and the two medical statements. Looking at it as a whole, a totality, I would suggest that fairness was not done.
So I think you're trying to segue a little bit to your second argument. I don't want to hold you up for too long in doing that. But as I read, I'm going to say Portillo because it says he spoke Spanish. As I read that case, the beginning of the kind of the important part for our argument today is where, as here, a recording exists, such testimony would pose a series of problems. I don't know what's in the record, so I'm not asking you to go beyond it, but I am sort of gleaning from our back and forth today that maybe no audio recording actually exists, rather than the Commonwealth having stripped out audio and provided only video. I certainly hope that did not happen. In the absence of the existence of a recording, don't the regular rules apply?
Okay. The Commonwealth suggested that they were going to provide a video without audio at the motion in limine. There was no explanation as to why they would provide a video without audio, but that it was, and then they wanted their officer to testify to the substance of the statements that had not been, and no transcript had been provided. They never said that they were not able to get said transcript. That is not in the record, and there's nothing indicating that. So therefore, if they did not have audio and they could not get, then one would suggest, let me back up. If they never suggested that they couldn't get a transcript, then one would think that they had the capability. They did not say that. They did not say that it was impossible.
Isn't that's an interesting analysis. If they didn't have the audio to provide to defense counsel, Isn't it another fair assumption that maybe there was something wrong with it?
But I would,
I mean, you're asking us to make an assumption.
I know,
And
it's
I'm
a-
asking the reverse assumption if we don't know.
and it's a difficult case not to circle back on one's argument, and trust me, I've gone through it. However, I would again suggest that during the motion in limine, when it was raised, that there was no transcript, and the trial judge said he was going to keep out the substance of the video for the case in chief. At no point did the Commonwealth suggest that, Judge, we weren't able to get a transcript, at least, and certainly my sister can correct me if I'm wrong on that fact, but it is my recollection that that was never suggested by the Commonwealth, and therefore I would suggest that this court could infer that that was something they had the capability of doing and did not. If there's no further questions, I will rest on my brief.
Thank you.
Thank you.
All right, Attorney Horn.
Good morning. May it please the court. Megan Horn, Assistant District Attorney for Middlesex for the Commonwealth. In this case, the defendant testified before the jury that he had been attacked by the brothers in this case, Mr. Gomez and Mr. Barbosa, both of them wielding knives. One of them had struck him with a glass bottle and that he had fended off both of them with a fallen tree limb. However, on the night of that incident, he told a police officer that he had instead been attacked by 5 individuals, including the brothers, that none of them were wielding knives. He'd still been hit with a glass bottle, but somewhere else on his body.
Did the Commonwealth have an audio copy?
Yes, and to the extent that the record is clear, the record supports that the Commonwealth did provide defense counsel with a recording with the audio intact.
Where is that in the record?
In the Commonwealth Supplemental Record Appendix on the 2022 docket, the Commonwealth provided, excuse me while I've referred to my notes, there is a copy of the Commonwealth's supplemental, the Commonwealth's supplemental notice of discovery, which includes a reference to the recording with audio.
I'm sorry, I'm not finding it. It's in the supplemental appendix that you filed with this court?
Yes, I apologize. It is on the older docket, which was compiled with this docket for appeal. I'd be happy to submit additional materials for this docket's review. In this instant brief, the audio wasn't referenced as an issue, but on the previous docket referencing these same issues, that was compiled into this instant docket for appeal. The Commonwealth did submit a supplemental record appendix, which included this material.
So can I just ask you this, and I would speak for myself saying, would appreciate that, having that, but the evidence that the defendant is in a docket? Because generally, the dockets are Commonwealth-provided tape or whatever. Does it specify both audio and visual in what?
On the notice of discovery, it does specify that the recording had both audio and video.
Okay.
I will also draw your attention to the transcripts. In litigating the issue of the recording, defense counsel says, we do have a recording, but the Commonwealth is not putting it in reference to the recording itself, which I can only understand to mean both video and audio, because this was both in reference to, excuse me for a moment, this was in reference to the Commonwealth trying to introduce the video without audio, and
Can I jump in for just a sec and you can breathe? Because I know we're scary, but we're not that scary, I promise you. So just take a moment, okay? And it's fine. You're doing great. I wanted to remind you that we have the transcript of a hearing on March 13th, I think, 2025, which seems to be a hearing about this issue. It's before Judge McGrath, and at it, the Assistant District Attorney says that the audio I guess it's a motion for new trial based on a discovery violation. The Commonwealth didn't turn over audio, video, and the ADA says I filed a lengthy affidavit, and you can ask me about it, and there was a discovery notice that clearly stated this was an audio-video recorded interview that was filed. So I
That is
think that's
correct as
also
well.
useful.
The discovery notice was also filed as part of the record, as part of that motion for new trial. And I would just add that the proper venue for raising the issue for that potentially missing audio would be as a potential discovery violation as part of that motion for new trial.
So just so that I'm clear, you agree that the Commonwealth, and while there may be a disagreement as to whether it was just video or visual and audio, you have citations to why you say both were provided. You agree no transcript was provided and no translation from Spanish to English was provided, correct?
No transcript was provided. However, the substance of the statements was provided via police report containing essentially the substance of what the defendant said.
Right.
Let's talk about the motion in limine a little bit.
Yes.
Would you agree that there was an attempt made by the prosecutor to do an end around of Portillo?
I would disagree. I would submit that the Commonwealth was attempting to introduce the video without audio for other purposes, and then once the video was not introduced,
But then they also said they wanted the detective to summarize what the defendant said. I mean, that's exactly what Portillo says you can't do. I mean, am I misreading Portillo?
Portillo is not so clear. Portillo says that it's within the judge's discretion, and in this case, the judge did indeed use his discretion evaluating the evidence that was before him and decided that it was not appropriate to let that in.
So it makes sense to me if I were a judge sitting in the district court, for example. Can only imagine their docket and how busy they are on a daily basis. But seriously, if I've got a motion in limine and I as a judge don't speak Spanish, the prosecutor isn't going to play the video to the jury or to the judge to explain. They're going to say, here's the substance of what was said. It seems to me, reading between the lines, that since no translation was ever provided to the defendant, the Commonwealth isn't going to waste the court's time by hitting the video and watching everybody listen to an interview that nobody understands. And that's the basis of the argument, too, is that nobody knows exactly what was said. There's no way for a defense attorney to cross-examine whether the police intentionally or just made a mistake and said that the defendant said something that perhaps was misinterpreted, right?
I agree, and the audio should not come in. And in this case, there was no motion for the audio to come in.
So why can it come in by the Commonwealth for the substance of it after? Why can those statements come in?
In this case, it's a bit more similar to where there's a recorded statement, say in English, and a police officer can testify to the substance of that recorded statement in English. In that case, there would be no dispute that such a statement would be a police officer.
Every one of the concerns that I believe it was Justice Gantz who wrote Portillo, every single one of his concerns still exists, whether the statement is introduced in the case in chief or in rebuttal. How can we ignore that? He goes through, painfully some might say, what the concerns are. We're just supposed to ignore the concerns that are raised in Portillo? I know your answer is yes, we should, fairly, but why? What legal argument do you have to say we should just ignore all that?
Yes, we should, but ultimately, when they're introduced as rebuttal, they can't be taken for the truth of the matter as they would if they were introduced in a case in chief. which ultimately does reduce some of the concerns that are introduced in Portillo. And again, as
Is there a limiting instruction here that when the officer testified to something about what the defendant said that was different to what he said on direct examination, was there an inconsistent instruction given at that time?
there were limiting instructions, including about the lack of transcript. However, there was not one about rebuttal. And to the extent that the record is clear, there was not one requested by defense counsel. I understand that the sidebars were not very clear on this particular
No,
record.
they certainly weren't. So that means, as far as we're concerned, and more importantly, what the jury is concerned, all of those statements didn't just come in for credibility, they came in for the truth, right?
Yes, but again, that would have been on the defendant to request such a jury instruction.
So the problem here is that when the Commonwealth fails to do something it's required to do, in this instance, provide a translation of the defendant's statements to defense counsel, it's different in some ways, isn't it, than when a defendant testifies, says something inconsistent, and then the Commonwealth kind of rushes and says, oh, wait, the defendant now says, I didn't do it, I was with, Susie Q. And so then they rush and they get Susie Q to put on the stand. Defense counsel doesn't know what Susie Q is going to say, and there's an inconsistency. Like, no, I wasn't with the defendant. That seems to be, in my mind, some fair play, because the defendant made a decision after speaking with counsel to testify, running the risk that there might be inconsistent statements. Is it different here because the origin of the situation that the counsel has placed is that the Commonwealth failed to provide that transcript? So in other words, you're a defense attorney, and you're trying to counsel your client whether to testify or not. And you don't know exactly, other than taking, crediting what the police officer says you said, you don't know exactly what was said. So is it different here because the Commonwealth kind of started this problem?
To the extent I understand the question, that
Same.
I don't think this is a different situation at all. In this particular case, the trial judge made it very clear that in the statements were excluded from the case in chief. However, should the defendant choose to testify, they might come in. So defense counsel was on notice of that. And just referring to the transcripts again, the defense counsel did say that the statements were not a surprise to her. And again, she did have again, accounting for the possibility that perhaps there could be some discrepancy with the recording. There is a police report containing the substance of the defendant's statements. And I will just say there's been no argument that anything that the detective said on the stand about what the defendant said was inaccurate. There have been many arguments up to this point about potential inaccuracy, but there's been no argument about actual inaccuracy. It's really more of a procedural argument.
Counsel, can I go to the defendant's second argument for a moment?
Yes.
I think what the contested portions are, quote, the patient had driven himself home, was in, I think it should be police custody. He started complaining of headache and chest pain. I think it's no question that complaining of headache and chest pain would be necessary for purposes of diagnosis and treatment. But what about the first part? The patient had driven himself home, and more importantly, was in police custody. And then another one, I won't read the whole thing, but patient arrested, blah, blah, blah. How would those portions of statements have anything to do with diagnosis and treatment, and why are they admissible under the hospital exception?
So I would refer to what the trial judge said about these. They go to the timing, and that is relevant to treatment because the timing can be relevant to how a medical provider approaches a certain issue. They could be relevant to what the potential issue is, how to approach it, and frankly, they could be relevant to whether a potential patient is exaggerating an issue and whether that needs potential attention as well.
So if the statement said patient was at the movies, it wouldn't be any different, right? It's giving a time frame of where they were when they were experiencing headache or some sort of trauma. Is that your position, that it just so happened that this defendant was in custody, but the bigger picture is that when a doctor is treating or evaluating, he or she would find helpful how long it was and where the person was when they started feeling poorly?
Yes, in this case, it's certainly relevant that it would have been hours after the incident he's complaining of, and the fact that he managed to drive himself home, and that it was only after being arrested, which certainly could be relevant to a potential injury, that it began hurting hours later.
All right, I see that your time is up. The case is submitted. Well done by both of you. Thank you. The next case we'll call is 2023 P1424, Commonwealth versus Robert Blanchette. Attorney Ennis.
Good morning. Attorney Susan Ennis on behalf of Mr. Robert Blanchette. I would like to preface my argument by just stating that I realize that some of the language contained in my brief concerning the judge's conduct in conducting the hearing may have been a little bit harsh. And I certainly didn't mean any disrespect to the judge, but I realize that my tone may have been a little harsh, and I just wanted to comment on that. And I think that the judge obviously did the best that she could to accommodate all parties. Just wanted to preface my argument with that. Okay, the Fourth Amendment and Article 14 provide that every person has the right to be secure against unreasonable searches and seizures of his possessions. So if there is a warrantless search, the search or seizure is presumptively unreasonable and therefore presumptively unconstitutional.
Are you challenging that the BOLO did not give grounds for the stop itself?
I am, the BOLO gave grounds for the stop.
Okay.
I mean, there was, my argument was that it was disproportionate. The use of force was disproportionate to
Okay,
the circumstances.
I just wanted to make sure. So let's get to that.
Yeah.
The BOLO specifically says that the person who's in the car that they describe may have a gun. Now, again, you're not challenging the BOLO, you're not challenging how they got that information, you're not challenging that that information is accurate.
Well, I did actually, I'm sorry, I did actually challenge the indicia of reliability in my brief, so I did challenge.
So you are
I
challenging
did
the
challenge
BOLO.
yes, the information, where it came from, and the reliability of the person who actually transmitted the information.
Was that
'cause
challenged at the motion to suppress hearing by trial counsel or motion counsel?
Actually, the defendant was pro se in this
Okay.
case.
And can I just interrupt? I've had an opportunity to review your brief several times, and I don't see it. I see your start
I
point.
did say- I did
the degree of
add
force
that.
on page
I did.
12, that you start off as the degree of force. So as far as an argument before this court, about the reliability of the information and the authority of the police to stop based upon the be on the lookout,
I did
don't see
cite
it.
the,
and I don't want to take up your whole
Yeah,
time in
okay.
your argument, but
Okay.
assuming that
assuming I did that. I did
assuming
do-
that this
yeah.
time I'm right,
Okay.
that, can you just explain why you believe that the degree of force exceeded what the police ought to have done, given
The bolo.
information in the BOLO?
Okay, well, the reason would be that they conducted a felony stop, and it was a domestic assault and battery for the charge. There was no information that as I said, the person who transmitted the information was reliable. And basically that they immediately stopped him without even confirming his identity. I ordered him out of the car, made him, put his hands up, and basically,
Okay, let's go back to my question.
yeah.
The police, let's assume for a second that that issue is waived, or that we find that the BOLO was sufficient. The police have information that the person that's described in the BOLO may have a firearm. Are you suggesting that when they have that information, police are not supposed to immediately ask a person to get out of the car when they believe he has a firearm?
Well, a firearm in and of itself doesn't indicate any criminal activity. It's just the presence of a firearm does not indicate any criminal activity. Now, they actually ordered him out of the car before they even confirmed his identity. So basically, I'm saying that there was a lack of, probable cause at that point. Because they didn't confirm his identity, they immediately ordered him out of the car.
Why isn't the taking of the key a search incident to arrest?
Okay. Obviously, under General Laws, Chapter 276, Section 1, a search conducted incident to arrest can only be made for seizing fruits, instrumentalities, contraband, or other evidence of the crime for which the arrest has been made, in order to prevent its destruction or concealment, and removing any weapons the arrestee might use to resist his arrest or effect his escape. Property seized as a result of a search in violation of the provisions of this paragraph shall not be admissible in evidence in criminal proceedings. So the arrest was for a domestic assault and battery, unrelated to anything they could obtain from the keys. The keys didn't provide any evidence of the domestic assault and battery, so they couldn't.
But we're not talking about, you're not objecting to the keys having been offered in evidence. You're objecting, as I read your brief, you're objecting to the use of the keys to open a locked compartment in the car.
Well, actually, it being offered in evidence, I did cite Chapter 276, Section 1. The seizure of the keys could only be used as, arguably, if you take the position that the keys could be used as potential weapons, they could only take them, the police could only take those as a potential weapon. And I did cite one portion of my
So
brief.
I'm sorry that I'm confused about this, but your client was arrested.
Right.
Is it your position that when arrested, he's required to be taken and put in the jail cell with all his stuff on him unless it's a weapon?
See, that's the issue, is that the items were recovered from his person. So, I mean, once they were removed, they pose no danger to anybody, these keys. And the use of the keys after the seizure, as you pointed out, I did contest that also. First of all, the seizure of the keys, it could only be, if this court finds that it could be a potential weapon, it was a key fob, I mean, if this court does find it could be a potential weapon, it could only be removed as a potential weapon. It had no relationship whatsoever to the domestic assault and battery. So according to that statute,
Can I interrupt for a moment? Do you agree, or maybe say concede, that there was probable cause to arrest the defendant?
no, I probable cause to arrest him for
Domestic assault?
domestic assault after they determined his identity. That could be the, however,
And do you
It was still
agree-
unrelated to the
Right.
keys, so.
Do you agree that a search of the defendant's person incident to arrest is permissible?
Well, after a pat frisk, they did a pat frisk, basically. Before they confirmed his identity, I believe they just did a pat frisk. In any event, it could only be justified solely as a search for weapons. That's it, not anything to do with the crime. So it could only be removed for safety purposes. Once they took them away from him, they posed no threat to anybody.
And what
And
about
it was the investigative
inventory? The
investigative use of the keys to unlock the locked glove compartment of his vehicle. So the police had no information the vehicle had any connection to criminal activity, and no information linking the vehicle to the sole crime for which Mr. Blanchette was being arrested, domestic assault and battery.
What about the impoundment and inventory of the car?
Okay, the inventory, and I said that the Commonwealth failed to meet its burden of proof that this was a valid inventory search. The keys could not be used for investigative purposes under the limitations imposed by the legislature under General Laws, Chapter 276, Section 1, as a lawful search incident to arrest, because they couldn't do anything with the keys other than just take them from his person.
Is that what the inventory policy said?
The inventory policy, in this case, they introduced only the inventory policy for the car. So the keys were taken from his person. They should have introduced the inventory policy for any items found on his person. So if you look at the Commonwealth v. Peters case, if the inventory policy encompasses both a vehicle and the person of the arrestee, the written policy authorizing each should be introduced. And that is at Commonwealth v. Peters, 48 Mass Appeal Court 20, Note 6. So the Commonwealth bears the burden of introducing in evidence the written inventory policy in question. Failure to do so will likely result in allowance of the motion because it is the Commonwealth's burden to prove that the warrantless search was a lawful inventory search. So the requirement that standard police procedures for an inventory also be in writing also applies to searches of the person. So all we have here is the motor vehicle inventory policy. So that leaves, without the search of the person, without the inventory policy pursuant to the
How do
person.
we, in the policy, and this is at Record Appendix 102, it says a locked attached container, glove box, or trunk may be opened and inventoried if there is a key available. Isn't there a key available because when they searched the defendant, he had the keys on him?
There is not a key available because we don't know what's supposed to happen. Those keys were found on his person, not in the vehicle. So we don't know what, they were not, the motor vehicle policy inventory does not apply to items seized from his person, only from the vehicle.
So you
So
want
my
us-
argument is that they should have introduced both policies because the keys were found on his person, not in that vehicle, and there are specific limitations that they have to introduce the written inventory policy.
So you would agree with me that the inventory policy is a separate kind of legal entity which ultimately could result in evidence being introduced against your client, correct? For the safeguarding and keeping of items found in an individual's car, not for an investigative search, correct?
Well, I did argue that it was, they used the keys.
But the purpose, the true purpose of
Oh,
an
it's supposed to be a
inventory is to
caretaking.
protect the
Caretaking
property, right?
function, and that is
Okay,
the
so
limitations.
We agree on that, and the policy says keys available. And you want us to read into that policy keys available and found in the vehicle, not keys available.
Well, where do you find the key? I mean, the key, if he's on his person, then you need the inventory policy pursuant, that applies to his person, not that applies to the vehicle. I mean, in this case, there are other cases that don't really litigate this issue, to be honest with you. I mean, and other cases that have considered both the inventory search policy and the search incident to arrest have considered, policies of items found on the person, but those policies were introduced and they apply to the person.
Can I
I'm not asking you to read into anything. The law says that you have to introduce both policies, so it's not an inference.
And I just want to interject for a moment. Can we, given that we only have 2.5 minutes left, On your Rule 36, are you waiving the mathematical calculation and just going right to the constitutional
I'm
challenge?
actually just arguing the constitutional
That's
issue,
what I
and
thought.
I'll
Can you-
rest, yeah.
Thank you. Can you spend a little bit of time of why you think the 386 days is a violation of his constitutional right to a speedy trial?
Well, I mean, if you look at my, the submissions, I did submit some of the transcripts. I did, listen to the transcripts, and the transcripts did highlight that there were numerous delays caused by the Commonwealth's
Sure. So tell me about the four
laxity.
factors. Why those four factors in your benefit?
Well, there was, it resulted in pretrial incarceration. It was held without bail under 58A.
Okay, so the fourth factor about prejudice.
Yeah, and the Commonwealth failed to exercise due diligence in prosecuting the case, and as I highlighted in my brief, they were negligent in, they rescheduled things without him even being there.
Well, do you have any case that says just, and I'm not minimizing it, but the fact that the defendant remained in custody, that alone is prejudice under a constitutional claim?
I mean, it's certainly prejudice if he's going to remain in custody. I mean, if he resolved his case, he may not be in custody
Do
any
you have
longer.
a case that suggests that? Because I don't think it's as obvious as you, because when
Okay.
I hear prejudice, I think it means prejudice as to the defendant getting a fair trial.
No, there's actually cases that talk about prejudice even, I think, even if they're out of custody. So prejudice doesn't necessarily only mean just a lack of a fair trial. It encompasses many, many factors. So prejudice is not just related. I mean, I could follow up with, some research, but there is, the prejudice is shown, actually, I did cite DeRicco, and it's basically anything that, if he's in custody, clearly that's prejudicial to him as to his case. He's not able to be out, and, he was pro se too, which made it even worse.
Justice D'Angelo's question has to do with the prejudice in the legal sense. Obviously, it would be best for every human being not to be in custody. But in a legal sense, do you have a published case
Well, the
that
Barker
says
v.
you
Wingo.
I'm still speaking.
I'm sorry.
Do you have a published case that says that a person is prejudiced by having been detained?
So I cited Barker v. Wingo. The prejudice should be assessed in the light of the interests of the defendants to which the Speedy Trial Act was designed to protect. To prevent oppressive incarceration, minimize anxiety and concern of the accused, and to limit the possibility that the defense will be impaired. I mean, certainly he was impaired because he was in jail. He had to litigate his case from jail, basically. He was pro se. So,
All right, I see that your time is up or over, so we'll have to have the rest of the argument rest on your brief.
thank you very
Thank
much.
you.
I appreciate it.
All right,
Good morning,
Commonwealth
may
Attorney
it
Semmel.
please the court. I'm Catherine Semmel on behalf of the Commonwealth. If I could pick up where you left off with the speedy trial issue, I do think that there is some reference to the possibility that oppressive pretrial incarceration can be prejudice in DeRicco, which is cited in our brief. But I think the case law also makes clear that the greatest prejudice is exactly what the justice articulated, that is, prejudice in going to trial, and that is the
Reference in DeRicco, was that a Rule 36 violation, or was that a constitutional claim?
I think they were talking about a constitutional violation in that case. Regarding the
Can I back you up a little?
Yes.
Because this, to me, is very important. Is there a challenge to the BOLO itself, either at the motion to suppress hearing or on appeal?
no. Just to finish the speedy trial, the four factors, the length of delay in this case was barely over a year. The reasons for the delay, there was some issue with the way the prosecutor requested the ballistics that had changed, and that was an error, but there was no deliberate action by the Commonwealth to delay this case at all. Certainly the case was delayed by reason of the defendant's actions as well. and his assertion of right was first made at his motion to dismiss, and there was no prejudice to his case that has ever been asserted. So for all those reasons, I mean, to the extent it was raised at all, it was mentioned in passing in his written motion below, but there's no showing as to that. With regard to the claims that were made about the motion to suppress, first is the nature of the stop, which was proportionate to the circumstances confronting the officers. They had information not only that the individual by description and registration was carrying a firearm, but had recently committed a violent offense against a household member, and that this properly fueled the officer's safety concerns, which Officer Graham did testify to at the hearing, and supported their actions in going forward with guns drawn for safety reasons.
Do we have
Yes.
to see in the transcript that the officer actually feared for his safety in order to make that decision?
I'm sorry, do we have to?
We have to, because I don't recall there being anything. Maybe it's just
Here.
obvious, but I just want to hear
Here.
from you.
The officer did testify, I think it's at page 13 to 14 of the motion to suppress, and then maybe again at page 34, which I think I inaccurately typed in as 45, so sorry about that. But 13 to 14, definitely the officer described that they went forward because of officer safety concerns, that they went forward in that manner.
The officer testified that, in fact, he waited until a backup officer came to approach with
Yes.
guns drawn because of the fear.
Yes, exactly true. Regarding the seizure of the keys, it is discussed in the record as plural keys, not a singular key. There is no testimony fleshing this out. The defendant did not testify himself. There are some comments he made back and forth to the judge about it being in a plastic fob, but there's no evidence. He didn't ask the officers. There's no reason to believe that there wasn't some concern that that the keys seized from the defendant could be used as a weapon.
Is it necessary that that the officers have seized the keys out of concern that they be used as a weapon? Is that the only justification?
That's not the only justification, but it was the justification relied on in this case by the judge, and I think it was proper. And the search of the glove box was pursuant to the inventory policy, in that there was a key available to open that locked glove box, which is specifically what is permitted in the behavioral policy. The court has no further questions.
I actually do.
Yes.
Sorry. If we don't agree that the key was seized pursuant to 276, Section 1 as a potential weapon, could we use the inevitability of the
Yes.
getting the keys to justify fitting into the inventory policy?
I think so, yes. I mean, the requirement is the keys are available. Whether they had been seized or were still in the defendant's pocket, they would have been available at the scene, yes.
And I don't know if there's a case on this, but I'm sort of curious. If the police had gone back to the police station and in the context of booking, gotten the keys, could they then go back to the scene and search the car under the policy still? Or does the length of time sort of stop that chain? Because the defendant's argument is, I think, putting aside the keys being a weapon, is they shouldn't have seized the keys at that time. It wasn't appropriate. So it certainly would have been appropriate at booking, because you can't let somebody go into a cell with keys or anything like that. Could they then go back to the scene?
Possibly. I'm not sure I know the answer to that. I know definitely in the negative and in a different context that if you seize the keys at booking and you use them for an investigatory purpose, that's not proper. But I'm not sure if anything would prevent the officers from using them for an inventory.
It would come down to whether sort of the chain had stopped and now they are using it for an investigatory because the car's already
Or
either been.
inventory,
Okay.
yeah, that could
All right.
be.
Thank you. That's all.
All right.
Thank
Seeing
you.
no further questions, we'll submit on the briefs. Thank you.
Thank you
Well
very much.
argued. We're going to turn next to 2024, 1276, Commonwealth versus Oliveras. All right, Attorney Silvera.
Good morning, Your Honors. May it please the Court, Stacy Silvera for the defendant, James Oliveras, also known as Christian Hernandez, which is his true name. I just wanted to put that on the record. I know the Court is familiar with all the facts and has read the case thoroughly. I'd like to begin with the first issue. Obviously, this is a case that involves 15 direct controlled buys between the co-defendant in this case, Diane Arasota Guerrero, to one of two police officers in an undercover capacity. The first 14 of those buys are what are contained in the four corners of the affidavit. And the defendant's argument is that there's an insufficient nexus to search his residence, which was 137 Heard Street, for records, proceeds, drug paraphernalia, and I believe that's what it said, and the cell phone, although the cell phone is the primary issue. This is a case where there were two confidential informants. I would just note for the court, I'm not arguing that 14 controlled buys doesn't sufficiently corroborate the information they gave. What I'm arguing is that at most what they can be used for is giving the phone number. They did not identify the defendant at all. The two confidential informants knew of the person they contacted on the cell phone in this case as Louis. They told police they called Louis. Louis had a runner named Nancy. Nancy delivered the drugs to them. They were not asked to do a photographic identification. They were not asked to do a voice identification. So to the extent that the information from the confidential informants is relevant, I would say it's just simply the method of delivery. It doesn't identify the defendant as Louis, which is the primary issue in this case. With regard
Well, can
to
I
the
pause you
motion-
for just a moment? Because with respect to the search warrant for the home, the Heard Street property, does it really matter who your client was?
I think it does, Your Honor.
I mean, by which I mean his identity, you know, other than the person who sold the drugs used this cell phone number, and I know you don't agree with me on probably at least half of this, but I think it's fair from the affidavit. The person who sold the drugs used this, or who facilitated the sale of the drugs, arguably ran the runner, used this cell phone number. The cell phone number was found in and around the Heard Street apartment in connection with at least one day's narcotics-related communications, and was also in and around the apartment on other days. Isn't that adequate without knowing who actually regularly used that cell phone?
Correct. I mean, I do agree with Your Honor. I think this cell phone was used by Soto Guerrero. That's my argument, obviously, in the brief. She had the primary control of it. She controlled the stash house. She rented a room at 137 Heard Street. And when it was there overnight, it's, you know, there is no information to say whether she was there or not on those dates. I would note, I think the most important factor is that the defendant's location, I mean, obviously, this is a case that had ping warrants placing the phone, and the Commonwealth's main goal was to place the phone and the defendant at 137 Heard Street. That's the sufficient nexus, because there was no information the defendant ever sold drugs in this case. I'll get back to that. I'd suggest to this court, I looked, and I couldn't find a case at all the cases collected in Andre Fields and after, where the search of the defendant's residence was found proper, a sufficient nexus, where the defendant engaged in no drug dealing. He was never seen to engage in suspected drug dealing. He conducted no undercover buys. And in this case, Soto Guerrero, the co-defendant, she never went to the drug deals or returned from the 137 Heard Street. 7 of the deals, she was observed walking from 23 Eden Street. I would argue, or I would agree, there was sufficient probable cause to search 23 Eden Street, but she also returned there. She never once left or returned from 137 Heard Street. So I think what Your Honor is saying is there's one call that places it there, and does it really matter? They could have searched it if the police found Soto Guerrero was there, and I would suggest
No,
that's
I'm not going quite that far. I guess, do you think the distinction that the Commonwealth draws is relevant here, namely that the warrant that you're challenging was not a warrant for drugs?
Not really, Your Honor. I mean,
Why
yeah,
not?
I think in a way, it's a distinction without a difference in the sense that I would say Dillon is the primary case. And I think there's less information. And in Dillon, the court found records, proceeds. The warrant was for records, proceeds, paraphernalia, not drugs. And there was more information, more connection in Dillon. In Dillon, the defendant had been seen engaging in at least one drug deal. There were 2 residences, again in Dillon. One controlled buy occurred at the first residence, and there was a Commonwealth a confidential informant statement tying the defendant's drug deal. He was selling drugs from the second residence. We don't have that in this case. In our case, there is no CI statement, which I would argue is significant. It's actually what Justice Henry and her concurrence and Andre Field divides the cases on. There's literally the confidential informants here have no information whatsoever about the home and don't ever suggest that the defendant sold drugs there, nor was he ever seen leaving or even selling drugs. So
I just want to make sure I'm crystal clear. Do you agree, or do you not object to my statement, which is as follows? There was probable cause. The affidavit in support of the search warrant provided probable cause to search 137 Heard Street. I understand your argument about your defendant's lack of culpability or evidence tying him, but do you agree that the affidavit provided probable cause to search that location?
Your Honor, I would say no. I would say there are 2 dates, which the Commonwealth notes of the 14 dates in the affidavit. July 1st, the ping data located the phone at 137 Heard Street at some point. I don't think there is a dispute in the evidence that Soto Guerrero lived there, and living at a place is not sufficiently particularized information with regard to a nexus. I think the nexus goes to 23 Eden Street, where she was dealing out of, and she had her stash house and she had her bedroom with her locked door. Even if you were to say the phone being there, which is what I think I understand, the Soto Guerrero had the phone, regardless of who had it. It's at 137 Heard Street. I think what Justice Hershfang said, there are 2 instances it's located there. That's it for the 14th. Only one time was it located there during a buy on July 1st. The defendant's location is not given in the affidavit, actually for the first 13 buys.
I'm just focusing on the home itself and the phone versus who's guilty, right? I'm just looking at that search warrant. Does it support probable cause for the police to go into the home and look for evidence of a crime?
My argument is it's not enough to search the home for where the cell phone's only shown there. I mean, the police had over 6 months of surveillance and ping data, which presumably they could have received information on where the phone was located. Sure, it was there and she lived there at different times, but the date's important. There are only 2 of these dates where the phone is actually located at, for the controlled buys, 137 Heard Street. And my argument is that it's not enough. I think the phone travels with Soto Guerrero actually on October 30th, the second date. She had the phone in the morning. She left in a Cadillac. She went to 23 Eden Street. My client met her at 23 Eden Street, picked her up, and the phone travels with them. I mean, I think there's sufficient evidence, and even in the affidavit, they don't say it's the defendant's phone. They say it's the phone of the drug delivery service. But I would suggest to you that that's her phone. And the other point, which I think Justice Hershfang maybe got ahead of me on, which was the number of, I know the Commonwealth mentions that these are calls. I submit that the affiant was very accurate in what he wrote. He wrote called or contacted. Contacted with a cell phone suggests text. That means of the final 7 phone calls, or the final 7 controlled buys, only 1 was a phone call. The rest were text. That is not enough to show that it was the defendant's voice. The Commonwealth relies on a number of cases, and I would just note, again, they're distinguishable. Santiago, Escalera, Luthi, Lima, first of all, the defendant in those cases was shown to have left. There's just substantially more evidence of a nexus. This defendant had engaged in controlled buys in all 4 cases. In Escalera, it was 4 controlled buys, 2 suspected buys. Lima was 2 controlled, 2 suspected.
And the warrants in those cases, were they for drugs or paperwork of the business?
Well, Santiago was for just records and proceeds. But again, they did find a nexus, but there was also one of the drug deals, the defendant originated at the location. There was a Commonwealth, there was a confidential informant statement, which is not in this case, tying drug dealing to the location, which would suggest.
I guess you keep coming back to that, and obviously that's a much stronger case, but
Well,
I think it's certainly not a surprise to anyone that it is common practice, especially in a larger or, non-individual drug trafficking organization, to try to keep the stash away from the principal's residence. And so the notion that there were no deals to and from the suspected residence, that there was no, someone coming and going with narcotics is neither here nor there with respect to whether there might be paperwork there.
Right, but I would suggest to you that a Commonwealth, a confidential informant statement that a defendant sells drugs out of the house is.
Oh, it's way stronger. There's no
There's
question.
likely to be paperwork in the house. And I'd note for you that, I asked the court to take judicial notice of it in my brief, but it's mentioned in the defendant's motion to suppress. This was a prepaid cell phone. Clearly, there weren't going to be, the police knew this through the ping warrants, there weren't going to be records from the cell phones. The question was there a ledger? And Soto Guerrero walked back and forth from 23 Eden Street. The reasonable inference is that the drugs and any ledgers would be kept at 23
Why is
Eden
it the
Street.
reasonable inference that the ledger would be with the drugs, as opposed to that the ledger would be with the person who was running the operation?
Well, I think in this case, the reasonable inference is that the mastermind is Soto Guerrero. There's no evidence even in this case. Officer Dineen gave testimony of what a drug, a drug delivery service of this scale would engage in, counter surveillance measures. I think the affidavit shows that that's what the co-defendant engaged in after she did a controlled buy. She would make phone calls. She would wait, surveil the area. All of the information about who was controlling this was Soto Guerrero. And I would suggest to the court that that the lack of information about 137 Hurd Street doesn't warrant an inference that it's more likely a register would be found at that house or a record of the drug sales than at the actual stash house.
But I think you have to be careful what question you're asking, because that's the question you're asking is not whether it's more likely it'll be in place A or place B. The question is, read favorably, to the Commonwealth, or even not, read objectively, but with the Commonwealth's theory in mind, does the affidavit in support of the search warrant rise above the probable cause threshold, which, as we all know, is relatively low?
Well, I understand, Your Honor. I would say that if we're thinking that the ledger is where the phone is, out of the 14 instances, only twice is the phone located even at 137 Hurd Street. It's not overwhelming evidence that somebody's communicating from 137 Hurd Street and that they're writing down in a notebook, which, to be fair, was found at trial. Wasn't before the motion judge. I would also just note 2 of the cases the Commonwealth relies on, Lima and Luthi, there's actual evidence in those cases that the defendant was using the phone inside the residence. And to get back to my client, not just generally about the search warrant at 137, my client was never observed or even placed at the same time on a drug deal with the cell phone in his apartment. There was a back door. I understand there was surveillance on the 30th. Police were out front surveilling. The defendant and the phone were both ping data, and the defendant were observed going into the house at around 2:45, and then surveillance terminates at 3:01. They don't reach out to do the controlled buy until approximately 2 hours later, I think an hour, maybe an hour and 40 minutes. There's no evidence of where he was.
Counsel, you're running low on time. I just
sure, I'm
wanted
sorry,
to
Your Honor.
ask you, on one of your other claims, I'm confused as to what discovery you say was not provided by the Commonwealth that under the rules they had to provide.
Regarding the third issue, yeah, recognizing that the Commonwealth had not rested its case at that point, the issue is that the defendant was not provided with any information that the police officer, Officer Lucas, was at the house that was being searched at, I believe he said 11 a.m. All the information that was provided in discovery to the defense attorney said that the officers were in place at 12:45, which is when the search happened. 11 o'clock, presumably, based on, I know I'm sort of out of time, but based on my brief, I'd suggest I'd rest on what I wrote in there, but that changes the dynamic, and it finally places the defendant and the cell phone at the time in the house, and it's problematic. And the argument is also, it's just highly prejudicial. I understand the judge had its discretion to do it, but it really felt like the defense attorney got sandbagged, for lack of a better word. He was happy to have the trooper recalled for an inadvertent mistake, not pointing out the $3,000 that Lucas had recovered, but then to go on and not even mention it the day before. Defense attorney had no knowledge this was coming, and he was not even on alert due to the police reports, I would suggest was an abuse of discretion.
All right, thank you.
Thank you. I'd rest on my brief.
All right. Attorney Marshall.
Good morning, and may it please the court, ADA Charlie Marshall for the Commonwealth, asking this court to affirm the defendant's convictions. First, in addressing the search warrant and nexus issue, I do want to remind this court that the relevant standard is probable cause, and all that is required is that the affidavit contain enough information for the issuing magistrate to determine that the items sought are, one, related to the criminal activity under investigation, and two, that they may reasonably be expected to be located at the place searched. It is in light of that low standard that I think we need to have this conversation. That being addressed...
So that sounds like you're not really very confident in your case.
So I don't mean to convey that, Justice Hershfang. Here, I think the court need look no further than the holding in Lima. So in Lima, the court found that where an affidavit establishes that a defendant was responsible for a large-scale drug operation, business records can be expected to be found at his residence, even where the drugs were not kept nor sold out of that residence. That holding, to me, reads directly on point to our circumstances here. In reaching that holding in Lima, the court relied on 5 specific findings. First, that it was reasonable to infer that the defendant was a drug dealer responsible for a large-scale operation, and they made that finding based on 2 controlled buys. Here, we had 14. 2, that in an operation of that scale, business records can be expected. They can be presumed based on, 1, the experience of the affiant, the law enforcement officers, and just common sense, as you indicated, Justice Hershfang. 3, that a defendant's custom specifically of arranging those sales through record-gathering cellular telephone calls, and the fact that the affidavit itself established that at least some of those calls arranging the deals happened while he was in the location, are specifically in support of probable cause. 4, police surveillance that provides sufficient evidence to infer that the defendant and the person arranging those sales resided at that address. The affiant's specific experience about drug operations, which there is an extensive portion of this affidavit that details this detective's extensive experience. And 6, lastly, the defendant's concealment of his residence. In that case, he did so through different bills and things being under different names. We don't necessarily have that here, but what we do have here is visual surveillance of him putting plastic wrap over the windows.
Okay,
I would suggest that that leads to the same conclusion.
Wasn't that late in the fall?
So
I mean, not to overshare, but I live in an old house, and there is plastic wrap on my windows in the winter. So
it was, and Your
also
Honor,
clear.
I'm not suggesting that that alone would be a controlling factor in establishing PC. In fact, the concealment wasn't in Lima either. It was kind of the last factor they dealt with. But here, it is a sufficient, at least, plus factor in light of everything else. So I do think that Lima is directly on point. I do not think that Dillon is on point. So a close reading of Dillon will show that basically in searching that house in Dillon, police relied on a single unreliable statement provided by an informant that the defendant sold drugs at that address without any police cooperation. And the court specifically noted that there was a lack of evidence speaking to a pattern of repeated activity giving rise to a reasonable inference that the drug dealer's residence was related to his operation. Here, that's the exact
Well,
opposite.
so
We have
what
a
do you
pattern.
have here? Because your friend on the other side said there's no evidence in the affidavit that links, I think, two things, right? That links the defendant to this phone and that links, I guess she conceded there was some evidence that he was in and around this building, but not sort of connected to his, we'll assume, his drug trafficking organization. So what's your best evidence linking him to the phone?
So I disagree with that representation. I think there's extensive evidence linking him to the phone. While the defendant's brief focuses specifically on the location of the phone and the ping data during specific buys, of which they only placed it in 137 Hurd Street on 2 specific buys, it ignores extensive visual surveillance in cooperation with that ping data that essentially inextricably links that phone to the defendant. He is seen going to Eden Street and coming back to 137 Hurd.
This is on July 19th or 20th.
Early
or
on
so?
in the
Yeah.
investigation. And at the same time, they're monitoring the ping data. The phone is moving at the exact same locations consistent with his movements. He then goes on different dates to Market Basket and different shops. He goes to the RMV, and they are doing visual surveillance following him to all those locations. And at the same time, the ping data is also consistent with the phone's location in that data. On one specific instance, the detective goes into the RMV, sees the defendant sitting there, checks the ping data, it's consistent. He watches him leave, checks the ping data, the phone leaves. So I think the surveillance that's ignored in defendant's brief inextricably links him to that phone.
What links it to the Hurd Street address?
So again, visual surveillance. He's seen at that address coming and going multiple times. He's seen parking in a parking spot labeled 137 in the back of that address. He's seen putting up plastic bags on the windows. He is seen, they do overnight surveillance on certain locations, and they're doing ping surveillance as well. The phone and he are at that address overnight. There's also evidence tying Nancy, Ms. Soto Guerrero, to that address, where she's doing things like checking the mailbox, taking out the trash, delivering bags to that address, albeit not directly after a sale, but showing up with bags, dropping them off, leaving without them. So I think all of that does support a sufficient showing of probable cause, and I think to find otherwise on this affidavit would be essentially to hold that so long as you sufficiently insulate yourself, you're basically rendered immune from prosecution just when you do not touch the drugs or sell the drugs out of that address. I think Lima stands for a different proposition, and I think this case is directly on point with Lima. I do want to turn to the sufficiency argument because I think it will be helpful to the court, because I actually don't think that I articulated the issues well enough in my brief on the sufficiency argument. So just as an initial matter, I think that the evidence is more than sufficient under the theory of aiding and abetting on all 16 charges. And I want to clarify that it is clear from the record that the theory that the Commonwealth pursued was aiding and abetting. Now, I will also acknowledge that the trial judge instructed both on aiding and abetting, but also gave a constructive possession argument, not at the request of the Commonwealth. I think the procedure of how that happened was that trial counsel, defense counsel, was confusing constructive possession with aiding and abetting. The first person to bring up constructive possession was the defense attorney during his directed verdict argument. He then filed a written motion arguing and focusing on constructive possession. But Zanetti, the controlling case on this, makes clear constructive possession and aiding and abetting are 2 totally different things.
But then wasn't there a jury question about constructive possession?
So there was, and I will get to that, because before I do, I want to state that throughout the entire case, the trial prosecutor was clear. They were moving on aiding and abetting. Closing, that's the only argument he made. That was supported, the theory most supported by the evidence. Constructive possession only really became an issue because of defense counsel. Following his directed verdict argument on constructive possession, there was then a jury instruction specific to the defendant's constructive possession, which then leads to this jury question. However, the defendant, being the one that raised the issue of constructive possession and incorrectly argued to the judge that we needed to prove constructive possession under aiding and abetting, him having done that, also he did not object to the ultimate instruction. So we're reviewing whether or not those confusing instructions, we're reviewing that on a substantial risk of a miscarriage of justice standard here. which again is serious doubt as to whether the defendant's guilt was fairly adjudicated. Now back to that question, Justice Hershfang. I believe that that question indicated that the jury was holding the Commonwealth to an even greater burden than they were required to prove. It indicates to me that they were essentially requiring both that we satisfy the elements of aiding and abetting and also constructive possession. So I don't know where the jury has indicated that they are hiring the Commonwealth to a higher standard of proof on a theory that they weren't even pursuing, that we can necessarily find that there is a substantial risk of a miscarriage of justice, leading this court to think that his guilt was unfairly adjudicated, especially when the evidence produced, although the Commonwealth did not pursue a constructive possession theory, it does satisfy it. So what you need to prove under constructive possession is knowledge of the object, here being the fentanyl, ability to exercise control of that object either directly or through another person. The defendant had been doing that for months. There were a series of 14 controlled buys, and an intent to exercise control of that object. He was the one in charge of this drug dealing distribution scheme. He was the one dispatching Nancy to these locations. He was the one selling the stash. So where the evidence sufficed to show his guilt on aiding and abetting and constructive possession, that is not a substantial risk of a miscarriage of justice. His guilt was fairly adjudicated. The Commonwealth was held, I believe, to a higher standard than needed to be based on defense counsel's misrepresentations. So all of that being the case, I think any argument that that creates a risk of a miscarriage of justice is a strained one. And I don't believe that I appropriately articulated that in my brief, so I did want to spend some time on that. On the aiding and abetting theory, too, that's simpler. All that needs to be proved, and Zedeni makes clear, is that the defendant knowingly participated in the commission of the crimes charge, and 2, that the defendant had or shared the requisite criminal intent. That is clear here. The case law also makes clear, specific to the trafficking charges, he doesn't need to know the exact amount of weight and where there's a large operation that he is distributing. It can be presumed that he knows it's at least a sufficient weight to satisfy that it is a stash and that he knows about the stash. Just to highlight for the court, ultimately there were approximately 70 grams of fentanyl recovered throughout the entirety of the investigation, both during the controlled buys, the last controlled buy, and the stash house. There were 20 grams distributed throughout the controlled buys just with the officers themselves. I think it's pretty clear that the defendant knew exactly how big of a stash that was in the other stash house. Turning to the last issue, that being the recall, and as Justice D'Angelo indicated, this discovery issue. So to answer your question, the discovery issue as argued by defense counsel, and I will mention addressed by the trial judge as a issue of fairness in discovery. Essentially, there was a trooper, that being Trooper Lucas, who wrote a report about the execution of the search warrant. He wrote essentially, and I apologize, I did not include this in my appendix, but I can get it to the court. He wrote that on that day of the executed search warrant, that approximately 12:45, pursuant to the investigation, they conducted the search warrant. The report was silent as to them showing up at 10 o'clock in the morning and sitting outside the house and not seeing anybody else come in and out. That to me is not a discovery violation. It wasn't that we had a report that detailed information that wasn't provided. As the trial judge correctly noted, sometimes officers are not perfect. They do not write everything in their reports. That's what cross-examination is for. This happens, almost at every trial. In recognition of that, the judge chose to not take an extreme measure of, excluding the remainder of his testimony, taking him off the stand.
Well, to be candid, I don't think the trial judge is accurate in what he said. If there's going to be a statement that it was not in a police report that the Commonwealth knows the witness is going to testify to, that is an inconsistency. And under the Commonwealth versus Vaughn, if there's going to be inconsistent testimony which the Commonwealth knows about, that's exculpatory and should be provided to the defendant prior to trial. So I think what it comes down to is, did the prosecutor know that the officer was going to testify to that and not provide it to the defendant?
So I think that's a reasonable reading of the transcript. It's silent as to a definitive answer to that question. But in adopting that just for the sake of argument, I still don't think the manner of addressing it that the trial judge took was an abuse of discretion, and that's ultimately what the standard is, in that it would, this court would have to find that it fell outside the realm of reasonable alternatives.
But can I interject for a moment? In your brief, you identify that actually it was provided, but maybe I'm mistaking it, in a photo, a surveillance photo, that he was connected to the house, and that was that at 10 o'clock or no? Is that a different date?
I believe that's at a different date, Your Honor. I'll have to check and get back to the court on that. And I definitely acknowledge that the report itself was turned over, but again, that report was silent as to what time they got there. But in also addressing the fairness issue, which the judge did not just look at this as a recall issue. He looked at it as an issue of fairness on the testimony and what remedies were available to the defendant, and deciding that the appropriate remedy was cross-examination, which trial counsel extensively took. He was cross-examination.
How is that a remedy?
Because it brings into credibility.
Is that his right?
But it brings into credibility that testimony, and a remedy has to be.
I'm missing you, counsel. If the trial judge acknowledges that there was an error of Commonwealth not providing it, what fairness is there in allowing the defendant to cross-examine on it? That's his right. He did nothing except say, okay, now you can cross-examine it. He didn't remedy anything.
So I disagree with that, Your Honor, and I also disagree that the trial judge acknowledged that there was error.
Well, that might be different. So how did he remedy anything?
By allowing cross-examination. I think that remedy has to be viewed in the other remedies available. Essentially, the judge could have suppressed that evidence from coming in, could have essentially taken the witness off the stand, not allowed them to testify, could have dismissed the case. I think that those are all very severe remedies, and the trial judge is in the best position to decide what the remedy is, being the trial judge and seeing the case play out. I don't think it was outside of the realm of reasonable alternatives to address it through cross-examination, and then ultimately allowed in closing argument to bring that up, which trial counsel again did. I don't think it warrants reversal to the extent that this court is convinced that there was an error.
All right, thank you. I see that your time is up. We'll consider the case submitted. Well done by both sides. And at this point, we'll take a morning recess. We should be back in about 10 minutes for the next three cases. right, we're back on the record. Now we turn to 25P 1166, Richard DiBona versus WAYFAIR LLC, and another. And we start with Attorney Mantell.
That's right. My name's
Okay.
Rob Mantell, and I represent Richard DiBona.
Thank you.
And with me are Thomas Galatano and Kathleen O'Toole. And we ask this court to reverse the dismissal of Mr. DiBona's retaliation claim. And it should do so because WAYFAIR overtly expressed retaliatory animus on multiple occasions. It stopped helping and supporting DiBona right after he complained. It destroyed documents, created false documents, and made various pretextual statements, which all create an inference of retaliation. Immediately after his first complaint of age discrimination on May 4th, his supervisor and the ultimate decision maker in this case, Alex Chang, eliminated one-to-one meetings, and she stopped giving effective, meaningful coaching to him. Moreover, as of the May 1st complaint, she immediately solicited negative feedback from his subordinates out of the usual cycle.
Prior to the age discrimination complaint, there was a PDP that indicated that there was some problems, correct?
PIP.
Sorry, PIP.
That is correct, and the judge below found that that PIP actually could be seen as pretextual retaliation for his request for caregiver roles over his children, and also the employer unilaterally withdrew the PIP because they realized it was improperly provided. It was a complete shock to him that he was on a PIP. He said, I thought I was doing fine, and that actually violated the protocol for PIPs. So actually, the judge in this case below relied on that argument that all this happened before the age discrimination complaint. But they did so by reaching back into the record and inventing evidence of poor performance that wasn't there. Incidents that they didn't even rely on as alleging poor performance. In one instance, they said, oh, he was provided, career goals at a May 24th meeting. Well, that May 24th meeting was a midterm review. It was a positive review, and Alex Chang testified it didn't represent any deficiency in his behavior. And the court relied on a March 2nd set of a memo where DiBona was tasked with bringing people to meetings. Well, this was a pre-existing problem before his leadership. Remember, he comes in as supervisor in February. She was telling him he has to be assigned to go clean this up. And the Superior Court said, look, this is evidence of his horrible leadership. It was invented. They didn't even put that in this statement of facts. So there was lots of evidence that the PIP did not represent actual concern over actual deficiencies, that it was actually pretext and anger over his request for caregiver roles. And,
Can I pause you for just 1 minute, because there are two threads that go through your argument, and I've had a little difficulty trying to figure out their relationship to each other. So there's obviously the age discrimination claim. There's also a claim about discrimination against your client because during COVID he had these additional obligations at home, as many of us did, that presumably, took him out of work from time to time or made him unavailable. Are those things related to each other, and if so, how?
Thank you. So the PIP was due to his caregiver role, retaliation for his caregiver role. After the PIP, he complains about caregiver retaliation and age discrimination. After that complaint of May 4th and later, then the retaliation turns to, we're mad at you for complaining about age discrimination. So one merges into the other.
So just to tease that out now, I asked you to combine it, and now I'm going to ask you to uncombine it again, because, why not? We're lawyers. Do you have any is there precedent, or are you asserting that whatever discrimination he suffered as a result of his caregiver role is actionable as an age discrimination claim?
No.
Okay, so as I think about it, I should think about the caregiver discrimination as sort of the backdrop or the thing that got the ball rolling?
Yes, and it's an explanation as to why the PIP, contemplated on April 28th, did not actually represent genuine concern over his work at that time. She was angry. And in fact, she was supposed to, under caregiver protocols, reach out to him, see what he needed. This is COVID. Everyone's working from home. Kids are at home. She doesn't do that. He reaches out to her twice. She doesn't respond at all.
So just one follow-up question. You should never trust a lawyer who says that. If the only thing in front of us was the failure to support and accommodate your client in his caregiver role, is that actionable?
Not in this case is 151B, and it's retaliation for complaining about age discrimination. Okay. Now, maybe there's an FMLA claim that could be possible, but not in this case.
Can I try to combine something else? At the time of the summary judgment decision, the judge knew, and it's in the record, about the discovery violations, correct?
Correct.
Did you or your clients ever try to use an adverse inference in support of the opposition for summary judgment?
Yes.
Where is that in the record? I couldn't find that. I know the motion in limine hearing, but that comes later.
Well, the summary judgment gets filed by defendants.
Yep.
At that moment, we file a motion for an adverse inference on spoliation. The motions are heard together.
Okay.
It's at the same time.
I guess, okay, but is there any precedent for a judge using an adverse inference regarding the destruction to deny a motion for summary judgment? I guess that's where I'm missing the connection.
Yes, and we cited to a case called Winkle. And basically, when you spoliate documents, you create an adverse inference, and you have to assume at summary judgment that a jury would draw that adverse inference. In this case, the adverse inference is that a retaliatory motive infected these Slack messages that they destroyed. Now, on June 5th, during the demand letter, we said, please save your Slack messages, June 5th, and they did not. And then a few months later, we filed with the MCAD. The MCAD sends them a notice saying, save your documents. They did not. The MCAD has regulations saying you have to save your documents. Common law says you have to save your documents, and they did not. And it took them well after, I think he was fired in July 2020, and they started saving documents like a year later. So the judge was understandably upset about this and said, yeah, the jury can draw an adverse inference. And if you do so, in fact, this is the slam dunk, this is why we win. If we can get an adverse inference based on that, that solves the case, because there's an inference of retaliation, and summary judgment shouldn't be granted if there's an inference of retaliation. And that's what the Winkle case says.
So can I just, though, it's a little perplexing to me, and I'm not advocating for evidence to be destroyed, but there still seems to be some causal connection that needs to be linked. And I understand it's motion for summary judgment, but still, there's an absence of any connection. So in other words, that would say that if I'm a judge in the Superior Court and I've got an age discrimination case, if there's ever a whiff that any document, regardless of how relevant it may or may not have been, could be like a resume, could have been your meeting time, oh, that got destroyed. that then you survive summary judgment just because there's destruction or spoliation? Is there a connection that needs to be at least linking this?
You don't have to get there because these Slack messages were among the decision makers at the time of the termination. They would be discussing this. And in fact, Ms. Chang testified, she said, we use Slack messages when we don't want a paper trail.
I read the testimony, and I don't think that's a fair characterization of that testimony.
She said we use emails when something's important.
Yes.
She was asked, well, what do you identify as important? She said, something that I don't want a paper trail for, or something that I do want a paper trail for. That's what she said. So if she wants something undercover, and by the way, the defense says, well, these individuals don't have the capacity to save these Slack messages. The record has hundreds of Slack messages because they're easily saved because they were saved by my client. They could have easily saved these Slack messages, cut and paste them, copy them.
But doesn't there have to be some evidence of some intent to retaliate? In other words, or that the decision was based upon some sort of discrimination?
Well, we have that. We have that in spades. For example, the decision maker says, I don't want to talk to him because he filed a complaint against me. That doesn't dissipate. That doesn't go away. She doesn't want to deal with him, and her actions, offering to give him severance instead of staying there, telling him during the PIP, hey, take time off, go look for other work. She didn't want to deal with him anymore. The testimony,
that might be evidence of a bad manager,
no,
potentially,
well, no.
but what evidence is there to support your claim?
Worse than that, when he was offered a PIP, he was offered severance at the same time, and we asked Ms. Murphy, why was that? She said he had complained about age discrimination. He was using time to support his age discrimination. He was indicating that he would not be working with management, that his priorities were different than what ours were, so we wanted him gone, so we offered him severance. That, the refusal to deal with him one-on-one, and the spoliation of the precise documents that would be discussing his PIP and termination all directly implicate retaliatory motive. On June 5th, he complains, the demand letter. From June 5th to June 22nd, they never meet with him. Counsel says that they meet with him weekly. They don't. They refuse to meet with him during the period that overlaps the development plan and the improvement plan. And they fail to coach him at the same time. And he's documenting this whole thing. That's what I mean when I say they gave up on him because of the complaints. They made it impossible. And by the way, he tried to transfer away from Ms. Chang. The complaint, paragraph 114, says, I'm trying to get out of here. Please let me transfer. And they refuse. And in their answer for paragraph 114, they admit to that. So he's trying to get away. They trap him there. They don't identify what he did wrong during the PIP period. There's plenty of cases that say if your articulated reason is so ambiguous that it can't be challenged, that it's so subjective, that is an indication of pretext, and that is weighed in the summary judgment calculus. Okay. Finally, they have this false evaluation that they gave to the MCAD. Their explanations are not credible and not based on personal knowledge. The evaluations, one of them mixed up the narrative sections. They cut and pasted. Paragraphs 1 to 5 became 5 to 9. They're saying it was a computer glitch. It's impossible for it to be a computer glitch. So the case of Scarlett versus Boston says if you're giving false statements to the MCAD, false documents to the MCAD, that can be seen as pretextual. And to conclude, I want to note that 2 weeks ago, a Suffolk County jury found that a different employee.
Counsel, You submitted a letter about that.
Yes.
That is outside the record. That is not something that we can consider. And I frankly, your opposing counsels filed an opposition. Tell me what authority you have, before you even tell me what's in the letter, although we know it, what authority do you have that we can consider a trial that happened months after that doesn't really involve your client as support for anything?
Okay. So my point is not that
Not the point. I want the authority that you have that a trial that happened afterwards that doesn't involve the same party, your client, has any relevance to our decision.
Verdrager, which says that similar discrimination against other people based on the same protected conduct is evidence. And this was the same conduct, retaliation based on raising an age discrimination complaint. Same thing, same building, same level, same everything. Thank you.
All right, thank you. Attorney Bannon.
May it please the court, Patrick Bannon for the respondent, Wayfair LLC. There's a number of points I'd like to clean up. I'd like to start with some quick ones. Ms. Chang and Mr. Stone did meet with Mr. DiBona on June 29th. That's after June 22nd, and 4 days before he was terminated. That's in the record in volume 2 at page 64. Ms. Chang solicited feedback about Mr. DiBona from his team in mid-April. That's before the May 4th complaint. Now, the feedback comes back on May 5th, but the suggestion that this was a retaliatory move to get feedback from his team to try to drum up criticism about him in retaliation for his May 4th complaint, it just doesn't work chronologically. This case is about whether the May 4th complaint caused Mr. DiBona's termination. And the most important point is that as of May 4th, Mr. DiBona was already in grave danger of being terminated. On April 28th, his boss said, "You're on a PIP, you have 10 days to improve," and she said, "You might want to use that time to look for another job." That's about it, and then Mr. DiBona emails Mr. Stone a day or two later that says, "I am about to be fired." That's about as grave danger of being terminated as it's possible for an employee to be. Now, Wayfair tables the PIP, and they instead put Mr. DiBona on what's called a PDP, a performance development plan. It's a lot of jargon, but there's an important difference between those two. If you're on a PIP and you don't succeed, you're going to be terminated. If you're on a performance development plan and you don't succeed, then you go on to a PIP. So Wayfair dialed it back, but it's ironic in a case about retaliation, Mr. DiBona's complaint on May 4th was the but-for cause, not of his termination, but of an extension of the period of time he was given to show improvement. He said, "You know, I haven't had a chance to talk with Ms. Chang about the caregiver responsibilities I have and how that's impacting me." And Wayfair said, "You know, that's a fair point. Ms. Chang should have talked to you about that. So we're taking you off the PIP. You're not on a 10-day clock. We're going to meet with you. You tell us what you need." That meeting happened. It's documented. It's in the record. It was confirmed back to him. Wayfair accommodated his caregiver accommodation needs, and then he was on a 28-day, not a 10-day, a 28-day performance development plan. And at the end of that, he was then on a 14-day PIP. So the idea that Wayfair, by moving back the PIP to a PDP, they were just trying to be fair. They weren't in any way suggesting that he was actually performing well on April 28th. And, you know, it's baffling. Mr. DiBona thinks that Ms. Chang was wrong to assess him so negatively on April 28th, that maybe she should have paid more attention to this information or that information. But we know for sure that she wasn't retaliating against him when she formed that. So the pre-complaint trajectory of his performance was steeply towards termination. And then Wayfair, to try to make sure that it was being fair in response to his complaint, gave him an easier, more gradual path with a greater chance of him succeeding. And that's pointed to as the retaliation. Ms. Chang did not cut Mr. DiBona off from feedback. Here's what actually happened. Mr. DiBona brings his complaint on May 4th. Wayfair talks to HR, talent relations, Farrell Murphy. She says to him, would you like to report to Mr. Stone instead of Ms. Chang? Because Mr. Stone is Ms. Chang's boss. So we'll basically take the person that you think is biased against you because of your age or biased against you because of your caregiver responsibilities. We can take her out of your performance management chain of command. Mr. DiBona says, no thanks. Wayfair then says, okay, well, Mr. Stone is going to then co-pilot along with Ms. Chang. When there's a call, Mr. Stone is going to be on it. And when there's an email or another communication, Mr. Stone is going to be copied. That's not hostility. That's actually recommended good practice. We cited in our brief an EEOC guidance that says when someone's complained about you and you think you might need to take further adverse action against them, it's a good idea to get a neutral person to evaluate what you're doing. And that's all that Ms. Chang, a 30-year-old manager, not super experienced at doing this, that's all that we were trying to do, is to have Mr. Stone look over Ms. Chang's shoulder to make sure that she was making fair and good judgment calls. And the idea that there wasn't feedback, there's a chunk of the record that's 49 pages long. If you look at volume 2 of the record from page 64 to page 112, it is dense. There's a lot of jargon that if you're a software engineer, you will be in your element, you'll understand it, and if you're not, you will have to read it really carefully. But there's 49 pages of feedback, all from May and June of 2020, about Mr. DiBona and what he should be improving.
Counsel, can I get into what I seem to think is almost like a legal inconsistency? The judge, you may not agree with it, but the judge made a finding that there was a destruction of what could have been relevant evidence. And she makes an or allows the jury to draw an adverse inference. But she doesn't seem to draw that same adverse inference against you, the moving party, in the summary judgment. How do we reconcile that?
Yes, it's a good question, Your Honor. And I think the two judges, they're deciding different questions. Judge Cowan decides to let the jury hear that Slack messages were lost. They weren't destroyed. You know, they were automatically going away every 90 days. And it was the middle of COVID, and Wayfair dropped the ball. We made a mistake. Slack messages are gone. We would have had to affirmatively stop them from going away, and we didn't. So we don't defend that. It was a mistake. But Judge Cowan had an age discrimination trial that was about to start. All that she ruled was, I'm not going to exclude from this trial the story about the Slack messages. So you, Mr. DiBona, can tell the jury that there were Slack messages and they weren't saved, and you, Wayfair, can explain why they weren't saved. And if the jury thinks that that's incriminating, they can so find. And if the jury thinks that it's not incriminating, they can so find. That's all that the judge did. It was purely just a prejudicial versus probative, should I exclude this evidence? Now, that's not what Judge Connolly had at the summary judgment phase.
I thought Judge Cowan did a little more. Didn't Judge Cowan also give an instruction that if they find that the destruction was made by your client, they can draw an adverse inference against you?
They could, but they didn't have to. That's what she ruled.
Because she left it to the fact finder to decide whether you destroyed the evidence.
But the central point, Your Honor, I think that the real key to this, and we've thought very hard about this on our side, the real key to this is there was no sufficiency of evidence issue before Judge Cowan. There was definitely going to be a trial on age discrimination. And the only question is, should the jury hear this thing about spoliation or should they not? For Judge Connolly, she had a case where she thought it was quite clear that Mr. DiBona was heading towards termination for reasons unrelated to his complaint. And so she was left to decide, well, does the lack of these Slack messages suffice to prove causation where I don't see anything else that's going to prove causation? That's a very different inquiry. It's like, do we need a trial solely because of the loss of the Slack messages versus we're having a trial, should we just let the jury hear about the Slack messages because it's not more prejudicial than probative? Those are two very different decisions, respectively.
Seems like that's fact-finding.
It's not, though, Your Honor, because one is a sufficiency of evidence determination. And when you have spoliation, we don't deny that Wayfair dropped the ball on keeping the Slack messages. But the question then is, what's the remedy? And so the Nally case, Nally versus Volkswagen, the SJC's leading case says that you would typically look at the wrongdoing by the defendant. Was it intentional versus reckless versus negligent? and then you look at the likelihood of prejudice. That's what Judge Connolly was doing, and this was argued about. It's not in her decision, she didn't write her reasoning, but it was argued about for 1/4 of the summary judgment here.
But hypothetically, if there were Slack messages that said, you know, what a pain, and I can't believe he's asking for this accommodation, or something of that nature, right? So understood your argument. What's the jury going to hear? Let them battle it out, and the jury can make the finding of fact. But if, hypothetically, that actually existed, these Slack messages that were incriminatory, right? Doesn't the judge then, in essence, make a determination that, oh, these really don't matter to the determination of retaliation, when they in fact could?
Well, the test, Your Honor, respectfully, is there has to be a reasonable certainty based on concrete evidence.
But how would one know? I mean, just the fact, in my hypothetical, they're destroyed. And in my hypothetical, they are damaging to you as far as the issue of retaliation. You go to a motion for summary judgment, and the judge is there any issue of material fact? Well, what do those Slack messages say? Because if the Slack messages potentially could have said something damaging as far as retaliation is concerned, how do I decide this at this level? How come in the age discrimination, the jury got to decide, and in the motion for summary judgment on retaliation, I just kind of left it there?
Your Honor, it's because you can't just base it on a speculation, maybe there would be evidence. There were depositions of 6 WAYFAIR witnesses. There were emails of all the WAYFAIR witnesses. And we know for sure that Ms. Cheng was not, retaliation is different from discrimination. You can know sometimes for sure that something's not retaliatory. Her opinion of Mr. DiBona pre-May 4th was definitely not retaliatory. And so you can always speculate.
Counsel, remember, summary judgment in a light most favorable to the non-moving party, right? So you can have all the depositions in the world from everybody that says it wasn't age discrimination. We fired him because he was a bad employee. But as to Justice Walsh's point, all it would take is one Slack letter to say, fire this guy, he's complaining about age discrimination. And we don't have that because they were missing.
And that's theoretically possible, Your Honor, in every case where there's spoliation. It's always theoretically possible that there was a Slack message that says, give Mr. DiBona a $1 billion bonus because he's such a great employee, and he could bring a claim for a $1 billion breach of contract. But the test is not theoretical possibility. The test is reasonable certainty based on concrete evidence. That's the test in Nally. And Judge Connolly is entitled to use her discretion to make this decision. If it's as fact-intensive and litigation-intensive as it's like an evidentiary ruling or a discovery ruling.
Did Judge Connolly, in the decision for summary judgment, ever account for the loss of the emails?
If you look at the 4 corners of the order on summary judgment, she doesn't mention it. But the same day, she made a docket notation, a handwritten notation and a docket notation on the cross motion about spoliation, and she said, we can save this for the trial.
Okay, that's my problem. She didn't even account for it in the summary judgment. Shouldn't she have at least said in her decision, if it's in your light most favorable, which it shouldn't be, but let's just say, I don't find there was destruction. I find it was just a mistake. It wasn't destruction, it was a mistake. Then you might have me and say, that's not accounted for. But when there's no decision made, when there's this destruction, that should err on the side of the non-moving party, shouldn't it? Somehow.
Obviously, we would love it if Judge Connolly had written her reasoning, because we know what it was. We argued with her for a long time about it, as did counsel for Mr. DiBona. And at one point in the argument, we've cited that in the transcript, Mr. DiBona starts to raise spoliation on retaliation specifically, and she says, wait a minute, before you get to spoliation, what do you do about this chronology where you're already going to be fired? And the light most favorable, Your Honor, you can put whatever light you want on April 28th. It's pre-May 4th. So in the light most favorable, it's not even logically possible for Ms. Cheng's April 28th opinion of Mr. DiBona to be retaliatory. It's not even logically possible. And so for that reason, spoliation is not going to rescue Mr. DiBona. And you know, if you look at the feedback that continues, including the feedback from his team, it's very clear he was not succeeding. No one thinks that Mr. DiBona was succeeding, not Ms. Chang, not Mr. Stone, not Mr. Stone's boss, Larison Crappy Yao, not the product manager who was an internal client of his, not his team. There's really no evidence that anyone thought he was succeeding in the job. So to think that there's a Slack message that's going to say, well, you know, he's actually great and we should keep him, but now that he's complained, let's throw him out of here. That's not logically impossible. It's just not proven to be likely.
The cast was set and the die was set when April 28th. You say that's it.
I don't say that it was set, but it certainly was making it. It makes it so that the timing will not support Mr. DiBona, that there's nothing suspicious about the fact that he was let go, given where he stood on April 28th. It takes the timing. You know, it doesn't mean that it's not impossible that you can retaliate against someone who's in hot water, but that's something that you'd have to prove. And we don't have that here. His reasons for why people are being hostile to him. Very quickly, lastly, Ms. Murphy says, how about some severance? And Mr. DiBona wants to argue that's hostile. That was in response to a 17-page demand letter in which Mr. DiBona asked for $900,000. So I'll leave my argument there. Thank you.
All right, thank you. The case is submitted. Hold on. All right, we'll next turn to IRENE SPERIDAKOS versus State Street Corporation, docket 2025 P1408. I'll remind the parties that this is partially impounded. I'm not sure why. And I don't want to mispronounce, counsel, your last name, so I'm going to allow you to both to introduce yourself so I don't make a mistake mispronouncing your name.
Sure. Lee Racich for the plaintiff appellant.
I was going to pronounce your name just like that.
Okay. Thank you. And may it please the panel, I represent the appellant here. She was terminated from State Street some time ago now. These events are coincidentally just right around 10 years ago that they were taking place. But you'll see there was a long investigation. There's reasons for that. We lost a summary judgment in the business litigation session. We're trying to resuscitate 3 of our claims. We have a breach of the implied covenant of good faith and fair dealing claim. We have a Wage Act claim. I'm going to explain how those are related. And then we also have a wrongful termination in violation of public policy claim.
Can we start with count 1, the wrongful termination?
Sure, yes, of course.
Doesn't, I would imagine, everyone who gets terminated feel like they were scapegoated in some way, shape, or form?
It's possible that people feel that way, sure.
Sure. So I guess my question, I can understand in a whistleblower situation. So we're talking about exceptions to the rules for at-will employees, right? And so far, it's been interpreted narrowly to have 4 exceptions. And so, for example, with the whistleblower, that makes sense to me because we want to encourage people to be able to have that ability to, kind of call out when something is going wrong. Here, other than working in corporate America, what is the, can you address, did you preserve it? And then B, if you want us to extend public policy, assuming it's not waived, what would that public policy be?
Yes, Your Honor. So the backdrop, as we've argued throughout, is that this termination and what they did with the deferred compensation is in the context of hundreds of millions of dollars of criminal investigation, which resulted in a deferred prosecution agreement. The bank had to pay hundreds of millions, and the executives stayed on board by and large. And we allege that Ms. SPERIDAKOS, as well as certain others, were unfairly scapegoated because the deferred prosecution includes express consideration for the bank's termination of employees. So we allege that in order to gain the benefit of avoiding loss of their license of a crucial part of their business, avoiding up to $600 million in criminal fines, they fired people who were innocent, and they got this benefit of the deferred prosecution agreement.
So I just want to make sure I'm remembering the chronology correctly. Your client was fired in what month of 2019?
July 25th, 2016.
2016, okay. And the DPA was from 2020?
2021, I believe, yep.
Okay. So your contention is that 5 years before entering into the DPA, State Street already kind of had in its sights the challenges that it was facing in convincing DOJ not to, and the SEC, not to pursue actions against it, and therefore sort of proactively shed employees that it could then rely on having fired in negotiating a DPA.
Yes, absolutely, Your Honor. And I mean, there are emails in the record from 2010 showing that the overbilling issue involving these SWIFT charges was known. It was being worked on by all these different departments at State Street. In 2015, State Street self-reported to the DOJ and state regulators. So they say in their statement of facts, State Street, that at the end of 2015 or early 2016, they say, the DOJ began its investigation. And that, I won't get into it now, but that makes sense. We filed the case in 2019. The DOJ stuff has been an issue every step of the way. So yes, we do allege that Wilmer Hale was brought in to do the interviews to queue this up for the self-reporting to the DOJ. We have no doubt in our minds that all of this was a very coordinated effort. I'm not saying that the law firm itself did anything wrong. That is not in the record at all. But what they did with that information, which we allege shows no involvement by Ms. SPERIDAKOS, that would give rise to a likelihood that she could be under forfeiting compensation under the malice standard or under the gross misconduct standard. It's just not in the record that they reviewed in 2016. It's not in the record that they reviewed later on in 2022 when they decided to unfreeze her compensation.
I want to ask you a question about the deferred comp. I think I know the answer, but I didn't see it in the briefing. Your client did get the money that the vesting of, that's a terrible sentence. There was a delay in the vesting of her deferred comp, but she eventually got the money, correct?
Yeah.
So what is the harm?
We filed the case in 2019 when she had been fired. She had no deferred comp. It was frozen. And then 3 years into the case, December 2022, they unfroze her compensation, the cash and the stock. It's about $500,000. The delay is the issue. The 6-year delay is the issue. There's loss of use of money. It's not as big of a case as it was with respect to the deferred compensation. We still say she was terminated wrongfully, but it's very important that the claim for breach of the implied covenant stands because as a result of that delay, that triggered a Wage Act violation, and we have the Reuter versus City of Methuen case, which holds that even paying somebody 3 weeks late is still a violation of the Wage Act.
I hear you on the Wage Act. I'm just trying to figure out in terms of, you need to show damages to be able to go ahead with a lawsuit. I mean, even if someone does you wrong, if it doesn't actually hurt you, you don't have a claim. So that piece of it is the lost time value of money, that the money would have been available sooner, she could have invested it, she could have used it, et cetera.
Precisely, Your Honor. Yeah, thank you. And I want to...
That deferred comp didn't vest, though, right? I mean, the DOJ came in and kind of put their hand on this, and it wasn't until 2022 that DOJ said, okay, investigation is over. And it seems as if it took State Street a short period of time, like 3 months, before they said, okay, we're giving you back, we're giving you the money. But it seems, am I wrong in saying that it wasn't vested?
Your Honor, the timeline, well, first of all, there's nothing in the record from DOJ saying State Street had to do this or that. There's one hearsay statement in the statement of facts saying that we weren't supposed to talk to employees while the DOJ thing was ongoing. What we're saying is that May 13th, 2016, State Street determines that they're going to freeze Ms. Speridakos' the compensation that was about to vest 2 days later on May 15th. And then they fired her in July, 2 months thereafter. So she clearly worked for the full vesting period here. If there was not a breach of the covenant of good faith and fair dealing, no question she would have had her compensation because she was still an employee until July. And that's what makes this case different from the Fortune versus National Cash Register cases and the cases that follow, where we have someone who's terminated on the brink of vesting. Here, there's no question that had they allegedly implemented the plan correctly, she definitely would have gotten that compensation while she was an employee.
The reason given for not giving the money is to do an investigation. And you're suggesting that the fact that they didn't find anything wrong is evidence of lack of good faith, correct?
That confirms it. That definitely confirms it.
Why does it confirm it? The fact that they were doing an investigation, it could have uncovered bad things, and then you certainly wouldn't be able to argue that that confirms it. You would say it categorically denies it. But they had a right to do an investigation, didn't they?
So they have a contractual right to do an investigation. We dropped our breach of contract claim. We don't think that they exercised good faith. And that's an issue of fact that we believe the lower court determined and took away from the jury. We have the entire record of what that ad hoc committee in May of 2013 or 2016 was basing its determination to freeze her compensation on. And we don't think that there's anything in there that warrants the freezing of her compensation. And in fact, we know Wilmer Hale interviewed 99 employees, and only, I think, 26 had their deferred compensation frozen. So there was some sort of level. They didn't just freeze everybody's. They made a determination, and in fact, the critical disputed fact in the statement of facts is number 32, and that's at Record Appendix 90, where State Street says it suspended vesting for only 26 employees, including IRENE Speridakos, where initial evidence showed that they knew or should have known about the overcharging of State Street's clients but failed to report it to their superiors. So they evaluated that block of evidence, and it's over 600 pages, and they concluded that there's enough that we're gonna freeze this and we're gonna see how it plays out. They didn't do that with everybody, and they had to exercise good faith in that determination to freeze. And that's what we're saying that they breached, because if you look at the evidence, they had gone through all of the clients being charged the $5 SWIFT
Well, are you
fee.
saying that sort of that statement alone shows the lack of good faith, that they came up with that statement, that she could be one of the people that knew about it and failed to report it, because there was no evidence of that?
Because that indicates that they took a record and they concluded that there was something more there that they needed to look into and investigate. And we say, no way, there wasn't. We know that ad hoc committee didn't even look at a single contract for Ms. Speridakos' clients. They didn't actually even check to see what her own clients were being billed.
Didn't they have the emails that we have in the record in which she's part of communications involving some of her clients who are paying the $5 fee?
Yeah, so
I guess I'm a little confused about why it was a failure, why the failure to go, assuming that it happened, look at a list of her clients is dispositive.
So we've addressed each of those specifically in our brief, and it's going to take me a while to get through it. But what I'm going to say about it here is that each of those emails is in a context of a fee negotiation, or in one instance, a new client coming on board, and Ms. Speridakos is asking another department, what's the fee going to be? It doesn't contradict in any way the fact that for years she and legal and billing and the controller and her superiors are all working on standardizing SWIFT fees. It doesn't excuse that in 2010 there's a memo that says the State Street already decided before that they were going to maintain 2 separate fees, and now we got to standardize everything. And that's Ms. Speridakos' supervisor on that. That's legal on that. I mean, she was. Yeah.
But I'm missing it, because it seems to me the fact that they didn't suspend all 99 employees, that might be a lack of good faith. They chose people to freeze where they thought there might be evidence of some, I'll call it wrongdoing. Why is that a lack of good faith? They deliberately chose certain people, and the people they chose are, and again, you have a view of what those emails show. In a light most favorable to them, they believed those emails showed the exact opposite, that she knew there was some wrongdoing going on. So why is that not good faith?
Well, first of all, we believe that that is exactly what the jury should be determining, and not the judge on summary judgment. The Chokel versus Genzyme court case says a breach of the covenant is a question of fact. A jury has to evaluate that to see whether these emails mean anything. I mean, one of them is involving a deal team, or preparation for a deal team meeting, where they're talking about what they're going to discuss at a discussion internally about what the fee should be. It's nowhere near concrete, and a jury needs to determine whether there was a good faith basis or not for the freezing of her compensation as opposed to other people.
With about 1 minute left, can you talk to us about the Wage Act and why you think that this case was wrongly decided on that count 4?
Yes, Your Honor, and the Wage Act one is fairly quick. I think I don't need to spend a lot of time on it. If there is a breach of the covenant of good faith and fair dealing, meaning if her compensation was frozen in May of 2016 unfairly, then it was paid late. It was, paid 6 years later. It could, any date that it was paid after her termination, or I'm sorry, after it would have vested, would have been paid late. And so the Wage Act comes into play there. I'm happy to get into more of that.
Even though it's not vested. I mean, your argument is that the freezing doesn't stop the ticking of the vesting date.
If the freezing had been done in breach of the covenant, then it should have vested on the 15th as scheduled. That is our argument. And I want to...
But it lives and dies with count 3.
Yes, it does, yep. And the public policy, I didn't get into that a whole lot, but the criminal activity here is the public policy. And in the Shea case, there's dicta that specifically says that we can look at whether another employee is trying to hide himself from criminal liability. That's in Shea, and we believe we're following that, not expanding. So,
All right, so I see your time is up.
Thank you very much.
Thank you. Justin, a brief.
Good morning, Your Honors. May it please the Court, Morgan Nyan from Nixon Peabody on behalf of State Street Corporation. This case is about an employer that did exactly what its contracts allow, exactly what the government asked, and ultimately paid the plaintiff every dollar of deferred compensation that's at issue in this case. State Street terminated an at-will employee after concluding that she knew or should have known that clients were being overcharged, a conclusion supported by plaintiff's own deposition admission that she knew clients were being overcharged. State Street then exercised its contractual right to suspend the vesting of plaintiff's deferred compensation pending an investigation that could not be concluded until the Department of Justice completed its parallel criminal probe.
So let me ask you, because this is such a great time divide here, 2 days before she vests with her deferred comp? I mean, so I think in part the argument is that whatever DOJ did in investigating up and until 2022, that decision on May 13th, 2016, if I have it correct, 2 days before, was a breach of your obligation, right, of fair dealing?
So on the day that State Street had the contractual right to do what it did. The contracts say we have the right to suspend pending an investigation. On the day it elected to make that decision, it had everything in hand that it needed to exercise its contractual rights. It had 2 interviews from plaintiff that were conducted by Wilmer Hale. It had a series of emails that they believed showed that she knew or should have known that clients were being overcharged. So it had that information in hand. Vesting dates come up every quarter. State Street has an obligation to its shareholders when it has information that it believes show that compensation should not be paid, an investigation should be performed, that it exercised those contractual rights, and it did that. There's no evidence here that it did that decision in bad faith. This is not like the Fortune line of cases. Those cases, the on the brink cases, are where the employer receives a windfall because they deprive the employee of compensation. There's no windfall here.
I understand in your brief, both the briefs were excellent, but the question I have is, was she singled out for the date in which, 2 days before her vesting, it was frozen, or were all 28 State Street employees, their potential deferred comp frozen at the same time?
She was not singled out. I'm not sure exactly what's in the record with respect to the other employees. Actually, you know, there's been lots of discussion about what may or may have happened with other employees. That's not in the record. All that's in the record is what happened with respect to the plaintiff here. And State Street had information that it was able to act upon to exercise its contractual rights on the day that it made that decision.
Right. So your brother's argument is that you cast too wide of a net, and you captured in that net not all 99, but 28, and one of the 28, his client. Later, the proof that she did nothing wrong was that the deferred comp was given back to her, that's evidence.
Sure, that's
right?
That's evidence in hindsight. The fact that, you know, the reason for the delay was because the Department of Justice was doing a criminal investigation. State Street did not know what would happen as a result. Ms. SPERIDAKOS could have been charged with a crime. State Street could have interviewed other employees that would provide information that would bear on her conduct. So it was completely reasonable and in good faith for State Street to wait for the government's investigation to conclude before making its determination about whether or not to ultimately find that the circumstances of forfeiture was not met, which it ultimately did. That actually shows good faith. It shows a good investigatory process that was run thoroughly, and State Street waited for all the facts to come in before making a decision.
I might agree with absolutely everything you just said about that the emails show X. But isn't that a question of fact that a jury has to decide? Because they take the position that the emails show the exact opposite. And they did that in the record. It seemed like to me the judge was making a little fact-finding here by saying that shows good faith. That's not what a judge is supposed to do in summary judgment.
The inquiry, though, is just whether State Street had enough to exercise its contractual right to perform an investigation in 2016. The ultimate conclusion of the investigation that happened in 2022, that's not the relevant inquiry for whether or not that contractual right is able to be exercised in good faith to continue to investigate.
But it's whether they had a right to exercise their contractual right as long as it's in good faith, correct? And
Correct.
that's a question of fact, isn't it?
I think the court rightfully found that on the evidence there is no reasonable circumstance under which you could find that what State Street did was in bad faith.
So that's the point. The burden isn't establishing good faith. You're saying at the motion for summary judgment stage that the plaintiff had to show some evidence of bad faith, the opposite, that you engage in good faith and fair dealings, correct?
Correct. There is no evidence of bad faith on this record. I'll turn to wrongful termination. First of all, plaintiff has waived any argument that this court should expand any of the existing exceptions to at-will employment. I didn't hear that addressed. Those exceptions are very narrow. The SJC has said they are to be construed narrowly. And
Why do you say they waived it, though? Because, I mean, they brought up the public policy argument. Now, sure, it's an expansion or an extension, but this isn't new. This was argued below, wasn't it?
It was not argued below. We did a very thorough review of their papers. They did not argue for an expansion.
Right. I agree. Didn't argue for expansion, but they argued that it fit within public policy.
They did argue that it did not fit with any of the 4 existing public policies. And, you know, to the extent they're arguing for an expansion for this new scapegoating theory, that's what's been waived. That theory, you know, the current exception should not be expanded to include that because it has no limiting principle. So, yeah, any time that any employee is disciplined by an employer while there's an ongoing criminal probe, they would have a potential wrongful termination claim. It doesn't make sense under these facts either. It is not against public policy for State Street to discipline employees that it finds were involved in some way in criminal conduct that furthers public policy. With regard to the Wage Act claim, So there's an additional basis for affirmance that the trial court did not reach. Under the SJC's decision in Boston Police Patrolmen's and Calixto, deferred compensation plans that provide that the compensation remains the property of the employer and where the employee receives tax benefits, the Wage Act doesn't apply at all to those plans. And here, plaintiff admitted both of those facts, that her deferred comp was State Street's property until it vested, and she received tax benefits. So there can be no Wage Act claim here.
So unvested deferred comp doesn't qualify. But
Correct.
your brother's argument is, but for you freezing and violating the covenant of fair dealing, good faith, then it would have vested. So the third issue, the Wage Act lives or dies with the breach of the covenant because it would have been vested. So do you agree that vested deferred compensation packages fall within the Wage Act?
Not under the SJC's decision in Boston Police Patrolmen. They expressly found that the kinds of deferred compensation plans at issue here are simply not subject to the Wage Act at all.
Where the employer holds on, right?
The facts about the timing of vesting and suspension of vesting was not at issue in those cases, but they held overall that deferred compensation plans are simply outside the confines of the Wage Act. But the Weems decision really deals with the uncontingent contingency that remains. So here, the compensation was still contingent until it vested, until the investigation was complete. It was not a wage. That's what the trial court found below. Unless your honors have any other questions, I'll rest on our papers.
Thank you. Well argued, both of you. And our sixth and final case of the day is 25P0463, Doe versus Sex Offender Registry Board. Again, I'll remind attorneys again about the impounded nature of the parties' names. All right. Good afternoon, Attorney Naring.
May it please the panel, Ilse Naring on behalf of Doe. Internet publication of Doe's registration information will not realistically warn off adult women from consenting to work with Doe as their pimp in commercial sexual activity. In accordance with the law for victim 1 and the examiner's finding for victim 2, both victims 1 and 2, they are victims of statutorily enumerated sex offense, trafficking victims for sexual servitude. However, they are also adult women who consented to Doe's pimping them in a business of commercial sexual activity. Doe and his victims were all in agreement that they wanted to earn money. Primary purpose was to secure possession of illegal substances. And most importantly, Doe did not force either victim 1 or victim 2 to engage in commercial sexual activity against their will. I say they worked with Doe despite his abuse, not because of his abuse.
And what's the evidence of that?
I beg your pardon?
What's the evidence of that?
Both women were free to leave, and they in fact did leave. Both women took sabbaticals from this activity only to later return. We know that in the fall of 2017, victim 1 had been working for Doe, but then she went into a residential drug treatment program, and she was there for a while, and then she responded to Doe's texts asking her to return to the activity and his photographs that he's texting of crack. We also know that victim 1 in the spring of 2018 says, I'm going to a hospital. She takes herself. She seems to be there inpatient for a week, presumably for medical treatment. And then she asks him to pick her up from the hospital and take her to a hotel to once again engage in commercial sexual activity. And it is the same for victim 2. She seems to be working for him from late January 2020 until mid-March 2020. And in that framework of time, the prosecutor says she was returning home periodically to visit her children, and there's some unhappiness because he's so stingy and takes control of all of her money that he won't even let her have enough to buy presents for her children. But she returns to the hotels again and again to engage in this activity, and then she stops in mid-March 2020 until late September 2020. And this is months of not engaging in this activity.
But wasn't
They're
there,
free to
can I interrupt for a moment? Doesn't that argument, isn't it belied by the record? I thought I remembered reading it, and there were text messages threatening violence if this was not this just, I'm a money maker and I'm not forcing you to do anything. That included threats of violence to at least one of the victim in reports of fear. I mean, regardless, it just doesn't seem as if that you could really cast this as this consensual, nonviolent relationship such that internet publication isn't warranted.
The thing about the text was that it was wipe the cocaine off the scale. So that is independent of the sex offense, which is knowingly enabling a person to engage in commercial sexual activity. Doe is a domestic abuser by his generic criminal record, and he is abusive emotionally to these women by their own account and from what we read in the texts. But he isn't forcing them in that you have to do this. He doesn't lock them in. He hasn't purchased them in some kind of a black market. And
Well, but isn't the evidence that he was taking the money?
He was taking their money.
And that he was providing them with the drugs to which they were addicted?
Yes, both of these women first meet Doe in his capacity as a drug dealer, and it's a company town in a way.
Right, and like a company town, you're really stuck buying from the company store, and you never actually have your own money to spend as you want, where you want.
But each of these women over and over left and then returned, and that these women weren't stupefied by him. They weren't forced to take the drugs to be stupefied and thus to submit to the commercial sexual activity. These are adult women who agree.
They're adult women with pretty poor choices available to them, right? I mean, I think, tell me if you think this is an unfair reading, but my reading of the examiner's decision seemed to imply that each of these women was fragile, suffered from a drug addiction, had, I'm not going to use the word chosen, but had determined to do sex work at some point in the past, came in contact with your client, did sex work in which he, provided the drugs and kept the money, was physically violent toward one of them on at least one occasion, that they would sometimes leave, maybe even get clean for a few months, but as is the nature of addiction, unsurprisingly, that didn't always last. And then getting back into the life, I think it can be sort of challenging to see it as an act of free will to choose to go back to your pimp and dealer in a moment when you've fallen off the wagon.
It's heartbreaking, I agree. However, the purpose of the sex offender registry is to protect vulnerable persons, and my understanding of what vulnerable persons are they are minors, and in addition to that, persons who have physical disabilities, whether it's old age, because 65 seems to be the limit, or below the age of consent, or intellectual disabilities. And that's what makes them vulnerable. All people have vulnerabilities, and my heart goes out to what Your Honor describes. But objectively, I do not believe that we have an interesting problem here, because trafficking is being caught in a very wide dragnet of the sex offenses in Massachusetts. However, in order for the registration legislation to comport with due process, SORB has to prove by clear and convincing evidence that internet publication will realistically serve to protect and against the sex offense. And here, the sex offense is knowingly enabling persons to engage in commercial sexual activity, and even assisting a consenting prostitute is sufficient to obtain the conviction. And victim 2 was a working prostitute when he met her in his capacity as a drug dealer. So yes, the circumstances are heartbreaking, but internet publication is not going to protect these women.
So I think that's your second argument, which you've made quite clearly here today and in your brief. I'd love it if you could talk for a little bit about your first argument, because I had a little more difficulty, and maybe it's only one argument, and that's why I had difficulty with it, but I had some difficulty following precisely what your first argument was, which, it's in the table of contents, it's Doe's level 2 classification must be modified to level 1 because the underlying facts of Doe's case did not support, by clear and convincing evidence, a determination for internet publication. Is it all the same argument? In other words, I'm sorry, I'm talking a lot. I'm trying to figure out what I'm saying. Is your fundamental argument what we've been talking about here today, that internet publication is not warranted here because there was an insufficient showing that it's going to have the effect that internet publication is supposed to have, and then if that's true, the classification must be reduced from level 2 to level 1? Okay. So that's not an independent argument. It's sort of two facets of the same argument.
I have 1-1, and so, yes, the substantial
Yeah, that's true. You do have
evidence
1-1.
did not support by
Okay.
clear and convincing evidence.
Okay. I just wanted to make sure, because I think SORB read it as two slightly distinct arguments, and so I wanted to make sure that I wasn't missing an argument you were making. But if I'm missing an argument you're not making, that's fine with me.
I understand. No clear and convincing substantial evidence, which is part of the standard of review. And I think in this case, to just get back to it a bit, is that how did this all start? Doe provides in victim 1 with information that he's printed out from the internet about sex trafficking and tells her it's worse than being a drug dealer. And despite then, that's just the internet, he's printed it out for her. Despite that, she shields him by getting a bank account and getting a mass ID card to get a bank account and renting the hotel rooms in her name. This internet publication of his registration information would not have served to prevent her.
It's not particularly her, though, because unfortunately, the victimization has already occurred, right? So the purpose of internet publication is to prevent more people stepping into the shoes of victim 1 and victim 2. So if I'm the mother of a high schooler and I hear that she's hanging around with a group and I find out that, boy, now I've realized my high schooler might start experimenting with some substances, okay, let me get them into counseling. And then I hear that the high schooler is in a location with your client. You don't think that would set off alarm bells for people who would use? Now, you know, the argument of, well, they're not going to read it, and even if they read it, they're not going to change their minds. Look at victim 1, victim 2. We're told of the risks of this type of behavior, but the internet publication could prevent that person, couldn't they, from spending more time with your client that might result at some point in them grooming them and them getting them convinced that this is a better way than to work at Applebee's. I think that's what his text was. You could be sober and work at Applebee's, or you could do this. And so doesn't internet publication help at least theoretically prevent another such person?
So the point here is that the internet publication determination is based on Doe's particularized and individualized facts, and in addition to that, past is prologue. And Doe does not, go into high schools to sell drugs to minors and then get them addicted and then enable them or suggest to them or recruit them into a life of commercial sexual activity. These are adult women who came to him and met him in his capacity as a drug dealer. It's a very different situation, and due process requires each of these three elements to be based on Doe's particularized facts, and the examiner is supposed to tell how realistically, based on Doe's individualized and particularized facts, the substantial evidence supports by clear and convincing evidence. And it's not theoretically, it's not punishment, it's due process in order for this registration legislation to comport with protected liberty and privacy interests. Each classification must be individualized.
Thank you.
My time, if there aren't any other questions.
Rest in your brief. Thank you. Attorney Yassin.
Good afternoon, Your Honors. Thank you. May it please the Court, Mohammed Yassin on behalf of the Sex Offender Registry Board. I think this case is clear. I think it should be obvious to the Court that sex trafficking is fundamentally non-consensual activity. Force, fraud, or coercion is not an element of the offense, and the statute recognizes it as fundamentally non-consensual. It is actually exploitation, which is what I think some of the justices had, in questioning Doe's attorney, pointed out that this is exploitation. These traffickers, and specifically Doe, targeted these victims based on their vulnerabilities, including their homelessness or inability to find stable housing, especially their dependency on substances.
How is internet publication going to protect these vulnerable women?
Right. Absolutely, Your Honor.
Type of vulnerable women,
Sure.
not these specific.
Yes, Your Honor. So the hearing examiner did explain that. He made explicit findings. He found that Doe is at risk of sexually offending again in this nature against those vulnerable victims, and that internet dissemination would be useful by allowing these potential victims to be aware of Doe's geographical situation or location, and to use that information as a tool to avoid coming into contact with Doe, especially in situations where they may become vulnerable to becoming additional victims of sex offenses. So as one example that was mentioned, if someone's trying to find a substance to purchase, perhaps they'll try to go out of their way to go to the sex trafficker, and perhaps they'll minimize the risk of them by being aware that Doe is at risk for committing this offense. And I would also emphasize, again, these victims tend to be vulnerable. They do have, support systems as well as, parents, siblings, friends who are looking out for them. And it makes sense for the information to be online because these potential victim support systems can use that information in assisting these victims for them to steer essentially clear of this type of offender.
Can I ask you about, and I know another panel of our court found one way, not binding on us at all, the grooming issue. I think when you hear when a person hears the word grooming, it automatically has connotations to it.
Right, absolutely.
Does there need to be expert testimony regarding that?
No, Your Honor, there does not need to be. I don't think that Doe sought any expert funds for that issue. He didn't really raise that issue. I know the terminology of that was argued in Doe's brief, the word or terminology grooming. I think it is, there's no consensus on what that definition is. The hearing examiner used that terminology. I think it is clear that Doe had emotionally and committed psychological abuse of the victim.
I don't think even opposing counsel is suggesting that the evidence didn't support what the finder found as to what he did. Mm-hmm. I think the objection is to using that term without any expert connecting it to the things that Doe did, which is usually what an expert does.
Sure. And as Your Honor pointed out, I mean, this is the case of an adult pedophile grooming a prepubescent child. This is the case of two adults. You've seen you've reviewed the evidence that Doe exploited these victims using psychological, threats of physical violence, emotional harm, and so I understand that a justice may view that terminology as being problematic, but I think overall this is a case where Doe manipulated the victims, he controlled them, and he exploited them. The hearing examiner used that terminology, grooming. I don't think that was necessarily an error, again, given the fact that Doe kind of eased the victims into this sexual offending behavior. And as was noted, when they had tried stepping out and trying to leave that lifestyle, would send text messages, including pictures of crack cocaine, to entice or coerce them to engage in that behavior again. So I don't think there was any error in terms of the hearing examiner's use of that terminology. I'd be happy to try to answer any additional questions that Your Honors may have. I think this is a clear and cut case. I just wanted to also emphasize, I think it is significant that the hearing examiner found Doe to pose a moderate risk of reoffense as well as a moderate degree of dangerousness. The regulations emphasize, as well as the case law under Doe 496501, that the determination as to efficacy of internet dissemination is to be made in consideration of risk of reoffense and degree of dangerousness. And we do have a number of factors indicating danger here, especially with respect to the actual victims. We have factors 8 applicable as well as 38, which the court may have noted. Doe actually committed violence against these victims, and one of the victims actually made a statement explaining how this had detrimentally impacted her. So I would respectfully request that the Honorable Court affirm the Level 2 classification, and I would rest on my brief unless there was any further questions.
All right. Sounds as if you can rest on your brief. With that, we'll bring the hearings to a close. I want to thank the court officers and the clerk's office, our excellent timekeeper, and our law clerks. All matters are under submission, and we'll have a decision, I won't say shortly, but within a reasonable time.
All rise.